We're live, people. I think we're live. So I just checked the stream before we went live, and there were 745 people waiting before the stream went live. And Fleet Lord Avatar, I just saw your comment from a while up the chat. I remember when it was a handful of people watching these streams, and it's actually a little bit of stress, but it's good stress. How is everybody doing? It's a beautiful Sunday evening. Finally, we're going to get the air conditioning fixed in our house by the time winter comes around. Audio's good, video's good. I just got my own notification, so that's always a good sign. This is going to be a good stream, everyone. There's good stuff to talk about, and good in the legal sense, not in the gossipy sense. There's going to be some follow-ups to be going on in the Millie Weaver case. I've been getting emails all day. I've been getting emails from Ohio attorneys. Never going to disclose anybody's name or anybody's information unless they specifically ask me to or want me to. It's an amazing situation. Smack Talk 3 Skywalker. Hope your day has gone well as well. I caught a fish today, so that's as much as I can ever ask for in a day, and it was a good bass. Okay, so standard intro. Thank you all for tuning in. This has turned into quite the awesome Sunday night ritual. I end up eating by like 10 o'clock or maybe 10:30, but it is not just well worth it. It is a privilege and an honor to do this. Robert's not in yet, so when he gets in, I'm going to bring him in. Standard intro, and Jay Satala or Jay Sataya, if you're watching, I thank you all in advance for any super chats. No, I have a fishing permit. I thank you all in advance for any super chats. Things have gotten to the point where I actually have trouble, and this is like a good problem to have, getting to all the super chats. I don't like people feeling as though I don't like people feeling bad in life or ever. So if you're going to feel bad if I don't get to your chat, despite having given a super chat, don't give it, because it's come to the point where I can't get to all the super chats, especially when they're not on topic. Obviously, the more on topic a chat, the easier it is. And if we get them in the beginning when Robert has yet to come, it also makes it easier for me to get to. Professor Chaos, the only way to get through, stuck at work on a Sunday, woo! Hopefully some awesome chicanery ahead. Well, the interesting thing is, just to tease the Millie Weaver, it's either going to be one of two things with Millie Weaver, and I'm going to repeat this when we get into it with Robert. Either all the charges have absolutely nothing to do with the documentary, and it's robbery because her mother came, shot some compromising or video evidence of child abuse. Then Millie and her husband tried to steal the phone, hence the robbery, domestic violence, tampering with evidence, and obstruction of justice. It's either that, which would make sense, but coincidence in terms of timing, or it relates to the documentary and the leaked video or the leaked information that was revealed in that documentary. Either way, to be followed, and definitely we're going to see where it goes. On the menu tonight, we're going to talk about that infamous, that 4-hour oral arguments hearing. I've made a list, by the way. I've actually now started taking notes. Flynn hearing. We're going to talk about the Flynn hearing. We're going to talk about the Clinton emails judgment, because it's interesting, especially in light of the Flynn hearing. Spygate, Carter Page. Robert's going to fill in some questions that I have on this. Finished it. The NRA win on the high-capacity ammunition judgment that just came down. Some interesting legal questions in that. What else? We're going to talk about the Kamala Harris question that has been the red herring of the week. We talked about it briefly with Uncivil Law on Friday. We're going to get to that. Jake Paul, Millie Weaver, Big Tech Antitrust. That's the schedule. That is the lineup. Let's see what we got here. Thanks for all the great law streams, James. Thank you very much. And we got Longfei Zhang says, Professor, work my super chat in. All right. Now, I don't like people. No, I like people a lot, actually. Yeah. Straight Arrow says, how much does the NWO pay? I've seen why is Sky Blue 923 taken. I'm sure it was a joke. Jokes oftentimes sound way too serious in the written word. So I do like to just take for granted people mean things in a good-natured way, and it just reads badly sometimes on the internet. Tony Nieves, Good one for Barnes regarding mask mandates. Suing under First Amendment for the chilling effect on speech regarding threats of arrest for not wearing mask. I don't know. You don't know where it's ever going to end. It's we're going to see. So let's see here. I want to bring up some questions that are not super chat and that are not. Yeah, the 4-hour Flynn hearing is a great sleep aid. No, it actually made me jittery and angry. Let me just go check my DMs and see if
it is a great sleep aid. No,
oh, that's me talking. See if Barnes is in. Well, Barnes has been reliable. So let's see if we can get some questions here that we. Do you guys hear my dog upstairs whining? I don't know if that's something we can hear. Anything on SCOTUS decision against the Soros organization? Maybe not tonight. We might get to it. That was not one of the things that I had done my best to look into prior to this. David, what kind of fish did I catch? It was a very large smallmouth bass. Beautiful, beautiful fish. Okay, so what do I do here? Robert's a little late. Maybe do I set up the Millie and then when Robert gets in, we just tackle the Millie Weaver case first? Let's do that. Oh, we hear the. Okay, no, it's not a poor doggy. She's just whining because she wants to eat, and she's a bottomless pit when it comes to eating. Let's see here. Let's. I guess we should start with the Millie Weaver. Oh, please ask Barnes what both parents being natural born means with regard to the qualifying to be Prez of the USA. Certainly will. Let me just take a picture of that so I don't forget. Let's see this. This is not a question I'm going to be able to answer, but Viva, is there anything we can do to help stop voter fraud, mail fraud when the election happens? I'm going to leave that to Barnes. I mean, I don't know. In Canada, we have pretty strict voter ID requirements when you go to vote. It's not something that you can easily. It's not something you can easily do. You have to have. You have to have identification, photo ID, and you have to have the evidence that you live at the last address where they mailed the thing to. It's a different thing in the States. And I see Robert. Okay, don't everyone be disappointed. His suit looks very business today. Let's bring him in. Robert, how you doing?
Good.
Looking good as always. I'm never doing the suit again, and I'm always just going to blame the air conditioning, even in the winter.
That works. I think somebody recommended we should get a shirt, and so I should wear one of the merch shirts.
Paul ruins everything so far. Is the most popular shirt I've ever done, so it's great.
Maybe we could do one that Viva Barnes one that just says Sally Yates is corrupt.
Maybe just Viva Barnes, and then we'll put very, very in fine print on the back.
Yeah, exactly. A little footnote.
How's your weekend been? Everything's good?
Yeah, good. I mean, a little busy, but nothing too busy.
Okay, awesome. Do we ask, I know everyone is asking, is there any update in any of the Trader Joe's or the Amy Cooper lawsuit that you could share with us?
No updates that can be shared, no.
Okay, that is a good answer. That facilitates getting into the actual stream. So, Robert, I said I've been doing homework on a Sunday. Kid's going to be pissed when he sees that I took one of his drawing papers. Let's start. We got to start. We'll start with the Flynn saga, the Flynn hearing, because I know I've got questions, and anybody, you don't feel obliged to put a super chat in. I'll try to get your questions about the hearing. Robert, I mean, you saw I imagine maybe you didn't see my summary. I was genuinely surprised at what I felt to be not a low level of law, because I don't want to. It's not like that, but I wasn't impressed with the hearing. It sounded very, I would say, almost amateur. I was taken aback by the amount of hypotheticals, how far they went with the hypotheticals, and the length to which they used hypotheticals instead of concrete examples. I mean, is that normal in the Court of Appeal?
Not precisely. I mean, to some degree. In other words, the hypotheticals, when used well, are designed to define the outer boundary of the policy impact of the precedent that they're about to write or publish. So to the extent that that's where they were at, then that was acceptable. But the problem was twofold. One, some of the hypotheticals really didn't go to anything that related to this case or would be impacted by this precedent. And the second one is they were almost all one-sided. I would have been more aggressive than either Sally Yates or the government was. I would have, when they started going that hypothetical about corrupt prosecutors and whatnot, I would have said, well, here's why we have the separation of powers. let's say we decide that we think the government decides they think Judge Sullivan is doing what he's doing because he took a bribe from, I don't know, a Barack Obama ally. And so consequently, we, the government, are going to decide to grand jury the judge to inquire into all of his reasonings for why he's been doing what he's been doing and what he's been saying, just to make sure Judge Sullivan didn't take a bribe from an Obama ally. That would have pushed back and exposed the other side of the problematic aspect of their precedent. If the judiciary is not going to respect separation of powers for the executive branch, then why does the executive branch have to respect separation of powers for the judiciary? So this is why separation of powers exists. It isn't just so that the judiciary doesn't overstep on the executive. The judiciary, by not overstepping on the executive, creates a quid pro quo effectively where the executive won't overstep on the judiciary. I would have been much more aggressive. I wouldn't have been as kind and cordial to some degree as the others were. Also, I would have gone that route to be inflammatory, to point out the extreme consequences of the dangers of where they're going, not only to show the perilous aspects of the precedent they're about to publish, but also because once you're facing a panel that going in you should know is going to be overwhelmingly against you, given the 7-3 Democratic lean. And once you understand how judges operate in a political case, you understand that's where they're going to go. Then you need to, in order to change the equation, you need to throw some grenades. And sometimes lawyers don't understand why I do this in some cases, but it's when you can see that, okay, if this goes normal, my client loses, then what's the downside? What, the same thing that was going to happen anyway happens? So what? You might as well throw some grenades to see if you can change the equation. There are two judges who are amenable to a compromise outcome in this case. And what I said was I thought the Clinton judges were they needed to convince one or two of the three Clinton judges or convince Srinivasan. And I probably mispronunciated his name. I'm just going to call him Siri after the app, the little device, because I can't pronunciate his name. So, but Siri's the chief judge. He's an Obama appointee. He served under the Bush administration, though, as well. And it's an open secret in D.C. that he thinks he's going to be on the U.S. Supreme Court. So for him to preserve his access to the U.S. Supreme Court, he knows he needs to not offend and upset unduly Republicans in the Senate. And so the best way for him to do that would be to come up with some sort of compromise that isn't a pat on the back to Sullivan or a slap in the face to Flynn. And so that's why you saw him exploring different places. Then the one Clinton judge, it was not a surprise that the woman Clinton appointee would be a no-go. In my experience, women judges, particularly women Democratic judges, they are the demographic that if you did a poll, hate Trump, hate beyond all reason. So the probability they do anything that could be positive towards Trump was a no-go. Garland is obviously still ticked that he got he didn't get on the U.S. Supreme Court like he thought he was going to in 2016. That came out in some of his questioning. So it was left to the last one, Tenet. And he asked him, I think it's Tenet, I may be mispronouncing the name, but that judge is the one who said something that actually probably should have been thought about by the government all the way through, which was, when I ask for writs, you can ask for a writ of mandamus, which is the Court of Appeals ordering a district court to do something. Or I always often phrase it, or in the alternative, a writ of prohibition. The reason is sometimes it's interpreted that what you're really asking for isn't an order that they do something, but is an order that they not do something. Notably, he acknowledged in the hearing that, in fact, that was an appropriate remedy here. Now, nobody's asked for it, so they may evade the issue, though they have the inherent authority to extend it to a writ of prohibition. Because what really everybody was saying was it's the appointment of the amicus, the delay of the hearing, the inquiry into contempt that is the problematic aspect. Opening the door to potential subpoenas and evidentiary hearing, that's problematic. What they could have asked for is a writ of prohibition to prohibit him from ordering the amicus, prohibit him from having the amicus do anything further, prohibit him from basically doing anything other than holding a oral argument and issuing a ruling. If they're an honest court, or if Siri is smart and sees that as an effective compromise, that's what they'll do. And not only will they do that, they'll add in a disqualification. Now, you see they've come up with another excuse for why they can take the case en banc without Sullivan having standing.
That's actually, yes. Someone had asked, the court, it was Rickerfield. He said, why didn't the court address the fact that they made Sullivan a party to the suit? So this was a little complicated where they were talking about, is it sua sponte that they used the term?
Yes. And it is true they can sua sponte do it, but they didn't. So, I mean, I get it. They're going to retrospect and say, we could have, we're going to say we did it sua sponte.
Explain what sua sponte means for those who may not know.
It's Latin for on their own authority, or literally just means sua sponte is where the word spontaneous comes from. So it means on their own accord. They can spontaneously, if you will, take action regardless of what. They don't have to have a party request relief. They can, in this instance, say that we believe we need to take it.
Yeah, except now, I had pointed that out. They didn't do that, though. Nobody did it. Sullivan did it, right. And by doing it, made himself a party. And then they said, well, I don't know who brought up the issue of disqualification, but they bring it up. And then they say, well, we could have done it on our own, except we didn't. And because we could have, therefore, he hasn't made himself a party. Didn't make sense.
No. And it was the same. It was one. It may have been the same Clinton judge, but it may have even been the judge. Forget which judge it was, but it was a judge who also pointed out that this was all a circus at this stage. That ultimately only one outcome can come about. Why are we messing around and delaying that outcome? That was a judge that was otherwise hostile. So I think what you're seeing is the 3 Obama judges and the 1 female Clinton judge clearly want Sullivan to be affirmed with no limitations, no disqualification, nothing. Siri and Siri and the Clinton judge, the one dissenting potential Clinton judge, are the ones that are going to decide the case. Because if both of them break, then you would have a 5-5 split. And you can't reverse en banc on 5-5. They need 6-4. So so it's going to be up to Siri. Siri has a lot of influence as the chief judge. He's the intellectual heavyweight in that group on the Democratic side of the aisle. He's the practical one, pragmatic one. Think of him as like a Justice Roberts of the left. And you have a sense of who he is.
He sounds very smart. Incidentally, you're going to get totally nailed because apparently mispronouncing names now carries with it certain consequences.
Yes. Which was fascinating. It was amazing watching the media say that mispronouncing Kamala Harris's name meant that you were being racist. Apparently, they didn't know that that's an Indian name. That's not an African-American name. So they're like, this is anti-black. I was like, well, if you want to make the arguments anti-Indian, okay, but everybody mispronunciates names from certain. I mean, there's Polish friends of mine in Milwaukee. From Wisconsin Law School, I just quit pronouncing their name. I was like, there's no way I'm getting that last name.
Well,
right.
my last name's Freiheit, so I get Freiheit, but whatever. No, it's all the same. So
well, in Spanish, I'm Barnes, which actually I almost like better than Barnes. It sounds more like authoritative. Roberto Barnes. And I was like, oh, okay, I'll go with that.
So Srinivasan was very logical and meticulous. But in the outcome, if it's 5-5, then what happens? The order remains vacated because they vacated the panel's decision, and it goes back to Sullivan and the amicus?
Yep.
Oh, exactly would that be a circus? Holy cow.
Normally, they don't have even numbers. It's because they had to recuse. The Trump judge had to recuse. Otherwise, they would have had odd numbers, but they have even numbers. So so that's where I think what will really happen is Siri will use his authority to push everybody to try to be on the same page. So I think it's going to be some sort of hybrid decision. Put it this way: if they come down and they just affirm him, don't disqualify him, don't do anything to him, it will go. I'm sure either the government or Flynn's counsel, Sidney Powell, will petition the U.S. Supreme Court. Now, no assurances about what they'll do, but there are really unique facts here. So that's where I think Siri wants a decision that would preclude a Supreme Court taking the case without,
preclude setting a precedent that's going to come back to bite them in the not so near future, or everybody, and undermine basic separation of powers.
Exactly. And what they could do is they could just convert it to writ of prohibition.
So I want to get to that in a second. Thanks Scuba Steve for the super sticker. There was one comment here. You both look great. Grenades, yes. No, that wasn't the comment, but thank you very much, Vicky. Maybe briefly touch on the concept of legal fiction, re the Flynn case. I'm not sure what you mean by that. I think maybe we were getting into the discussion earlier, but STF.
Mark Garagos is a moron.
Yeah, so
here's my mantra, my advertising pitch for Mark Garagos. If you want to lose, hire Mark Garagos,
Well,
because nobody loses like he does.
I think you're mispronouncing his name also. I think it's Mark Garagos.
That may be deliberate in the result of prejudice, I confess.
So he says, have you heard Mark Garagos read Flynn? Unbelievably tedious in his analysis, legal eagle level.
The guy's just not smart. I mean, he was about to get Michael Jackson convicted until Michael Jackson figured out the guy was a moron. He did get Scott Peterson convicted. I mean, name a big case where the guy wins. I mean, the only thing he did is he managed to dodge getting. I mean, he's defending Jussie Smollett, to quote Dave Chappelle. So I can't be accused of prejudice because I'm using Dave Chappelle's pronunciation of Jussie Smollett. So and then he was connected to the Avenatti case, and I'll give him credit for dodging indictment. Congratulations on that. He's not a bright lawyer. He's very good at working the media, lousy at defending people at trial.
Well, arguably not so good at working the media because he got himself in a defamation case for things he said about the Osundaro brothers in the Jussie Smollett case.
I used to tell people the reason I opened an office in L.A. in California is I figured if an idiot like Garagos could get big cases, then this is open territory.
We got Corliss SD says, Barnes, re-separation of powers. Isn't it the fact that the FFs didn't intend for SCOTUS to sit in judgment on the actions of the other two, such that either need to pay attention to SCOTUS, a Chief Justice Marshall creation?
Yeah, what he means is Justice Marshall years ago decided that only the court gets to decide what is and isn't constitutional. Because the question, now that isn't always true, but here was the theory. Who gets to decide whether someone their actions are constitutional? Does the executive branch get to say, well, we have a duty to uphold the Constitution, so our final determination about our actions being constitutional is in fact final and not reviewable by the court? Same with legislative action. Justice Marshall said, no, we, the court, are in a unique position to be the final arbiters of what is and isn't constitutional. Now, they don't always do that. There are places they use the political question doctrine, standing doctrines, mootness doctrines to effectively allow the executive and legislative branch in certain contexts to be the final say on what is constitutional. Impeachment's one of those examples. Other examples are foreign affairs in certain contexts. So but yeah, that's what he's referencing. There are a lot of legal scholars who were critical of Marshall's interpretation that the judiciary was intended by the Constitution, FF, I assume they mean founding fathers, to be the final arbiter was constitutional. But Marshall did have some pragmatic arguments for it. His argument was, look, we don't have the power of the purse. We don't have the power of the sword. So us having the power of the finality as to what's constitutional makes sense because we're the least likely to abuse the constitutional in that time frame. That hasn't always proven true, but that was at least the logic, and there was an argument in his favor.
Okay, it's very interesting. And someone's the last says Barnes need to bring up the Free American Law Center more. We need a new ACLU that has not lost all impartiality.
That's for those who don't know, I helped co-found an organization called Free America Law Center that's designed to be sort of an ACLU for everybody, since the ACLU has abandoned people based on their political persuasion. So people can go to freeamericalawcenter.com. They can join. It's a very low monthly subscription rate. I provide access to I try to provide access to podcasts, videos, things like this, to make people informed and available and provide other information. But mostly it's to support an ACLU that actually meets its purpose and principle.
And speaking of political bias, I mean, the one people can, confirm whether or not they have the same sentiment, because I don't often listen to American Court of Appeal hearings. I was shocked, and it's a double-edged sword, but I was just shocked that you knew you could Google who was appointed, you knew where they were going to go, and they went there with such, I won't call it bias or partiality, but just with
it was over the top,
predetermined notions.
Exactly. The problem is that the liberal courts. Your point was very well taken, and it's the normal reaction of people who have not seen our justice system up close. It's a very deeply unsettling reality when you realize that the political partisan label of the judge will dictate how that judge will rule in any politically tinged case. And it's an unfortunate. It's gotten worse rather than better. I know people have commented say, "Well, do Republican judges do the same?" Well, yeah, because I'm predicting them too. So, but the difference is this: on the political right, within the legal academy, they believe in the rule of law, and so that's why it is far more likely that you'll see a Republican crossover to vote with Democrats than you'll see a Democratic appointee crossover and vote with Republicans. Democrats increasingly. I'm sorry. Go ahead.
Oh no, I was just going to say. I think it was Millett. It was almost like she was arguing
yes.
Sullivan's case for him through through Wilkinson in the questions she was at Beth through Beth, the questions she was asking him, it was outlandish. I mean, it was like she was asking the rhetorical questions in the way that framed the argument that she wanted the lawyer to present to her, and then went with it. And it was, I don't know if it was Millett in particular. There was just one. It was over the top.
Oh yeah. There were several that were really bad. I mean, and that Warren Rogers was really bad. The female Clinton appointee. So they're over the top, and what is there's fewer pragmatists up there. So the fact that Garland wasn't pragmatic, now maybe he would have been before the whole Supreme Court experience, but I was disappointed in that. The at least Clinton judges typically recognized, okay, what's our political risk on the other side to the integrity of the judicial process, et cetera. Unfortunately, there was very little of that. So it's a bad sign for where the courts are, that with a judge doing something outlandish and outrageous like Sullivan is doing. And by the way, the exact same D.C. Circuit turned around and immediately granted an emergency writ of mandamus to prevent Hillary Clinton from being deposed by Judicial Watch in her FOIA case.
Perfect segue. And it's an interesting thing in that case. Now, I forget the judges. It was a unanimous decision, I believe, in Clinton, right?
Yes, it was just a panel decision.
Okay, so here's one question. Okay, so for the Hillary Clinton, I'll summarize the facts, fill in the blanks if I've missed something. Judicial Watch filed a FOIA request back in 2014 about the Benghazi coverage, the political positions taken by politicians. They sought documentation, and by the judgment, it seemed that they were looking for written documentation, emails, not text messages, about the talking points that Susan Rice was going to be mentioning in her on-air coverage. It goes on for years, and this is what I presume you meant in terms of FOIA requests taking time. Judicial Watch filed the request. I think they filed the suit. It was years ago, right? It was 2016.
Yeah, well, it was before that, because what happened is Judicial Watch stumbled into the Hillary Clinton email scandal. They filed a FOIA suit, which is Freedom of Information Act, for those who wonder, to get the records about what internal communications took place in Benghazi. Once it came out that, for those who don't know the Benghazi Scandal, there's a great movie, 13 Hours, that documents it and details it. The SEAL team, the combined team, that military team, special ops team, ultimately wrote a book and disclosed the details of what happened. Basically, the U.S. abandoned its own ambassador to an Al-Qaeda raid that killed that ambassador and torched the embassy. It was right during the middle of the election in 2012 and happened in September, because it was on the eve of 9/11 that they did it. And despite the obviousness that that's what the source was, they instead blamed a small little filmmaker for making a film that upset radical Islamists, and that it was a spontaneous thing they had no reason to have notice of and no reason to have advanced knowledge of and no ability to defend. That guy, by the way, ended up getting railroaded by a federal judge simply for releasing that film, ended up going back to prison simply for releasing that film, ended up in a homeless clinic in California, that he was made the sacrificial lamb. The media covered up for it during the campaign. It came out after the campaign that the entire story was false, because the military people that were involved finally they lost their futures in the military by disclosing what happened, not disclosing anything confidential, disclosing what was not confidential, which was that it was an Al-Qaeda raid. There'd been advance warning of it. They were told to stand down. Everybody else was told to stand down, so they couldn't help people escape, couldn't protect the embassy. And Susan Rice, Hillary Clinton, and Barack Obama orchestrated a lie campaign to cover up the horror of what happened there and the tragedy of what happened there. From that, once Judicial Watch found out about it, they made a Freedom of Information Act request for all of the communications concerning it that you just detailed. And then they were stonewalled, so they filed suit. Midway through the suit, they found out that Hillary Clinton had a secret email server that was outside the state. That's the only reason why any of that ever got disclosed. It's why I always tell people to bring Freedom of Information Act claims, because you never know what you will stumble into. From that, there's been all kinds of delays at getting the relevant records. Finally, it was Judge Sullivan, same Judge Sullivan, who was so outraged by all the delay that he ordered Hillary Clinton to take a deposition. And she immediately said, this is outrageous, demanded a writ of mandamus. And by the way, writ of mandamuses almost never occur to stop discovery in a civil suit. You talk about having alternative remedies available.
Well, this is the number one question I had, and I couldn't. I was going to do this video yesterday, but I had too many fundamental questions. Is there no such thing as an interlocutory appeal or an appeal of an interlocutory decision in U.S. courts?
Only by discretion. So you can file an interlocutory appeal, but they can deny it. It's not an appeal as of right.
Okay.
So when you file a writ request, they have to rule on it.
Yeah, but do you not have to file the motion for permission to appeal and then get rejected before not having that as a viable recourse from an interlocutory being in the midst that is not a final decision? So you have a number of decisions during trial, just for everybody who's listening. Some of them might pertain to evidence. Some of them might pertain to discoveries. If it's not a final judgment, so it doesn't adjudicate on the ultimate issue, but you need to ask for permission to appeal because it does not. It's not a decision on the final issue. So I'm just saying, okay, they got permission to examine. If they didn't like that, make a motion for permission to appeal, and then if that gets dismissed, then there's no other recourse. Then you do a mandamus.
Well, but there's still plenty of recourses. She could have gone to the deposition, refused to answer, right, and then gone through the contempt proceedings, and then you have an automatic right of appeal through a contempt proceeding. So there are far more remedies available in the discovery. I have never seen a writ of mandamus issued to prevent a deposition of someone who's not an existing government official. It's never happened. So it's extraordinary. And yet they treat it like, oh, obviously this relief had to be, and just showed how political they are. There's no way to combine the decision they're about to issue in Flynn with the decision they just issued in Clinton. And they are so politically unaware, they don't realize the whole world sees this. And yes, people that are in their political camp are going to be with them. The problem is they are slowly, steadily destroying the integrity and the perception of impartiality of the American federal judiciary. And they're doing it to the one group of people that was the most law and order oriented audience in the world, which were American conservative Republicans. They're educating them, like in the past, they've educated the left, that our judicial system is highly partial, highly prejudicial, and highly partisan.
So actually, this is a good question I forgot to ask before. President Trump for Dummies. Is Jen Flynn still under gag order? Do you think that's why the judge is dragging this out till after the election? Is Flynn still?
He was never under a gag order.
Okay, so people might be confusing Stone with Flynn. So Flynn can talk if you want.
Oh, yeah. My guess is that Sullivan has probably advised him not to necessarily, and I respect that. That is the typical choice. I would advise him to talk. Now, he's talked a little bit. He's done, but not about the case. But if I were in his shoes, I would have him doing some interviews. So,
and now just
that's my take.
To push back on something in the Hillary case. So, the mandamus was issued after Hillary was in fact deposed. Hillary was deposed in the Judicial Watch lawsuit, right?
No, my understanding, she wasn't. It was ordered that she be deposed, but she hadn't been deposed yet.
I thought she had been deposed a first time, and that this was a second deposition. I saw in the, maybe someone can correct us. This might be just a pure matter of fact. If anyone knows the answer, I thought she was deposed, and this was an extended deposition on other issues that hadn't been covered in the first deposition. But maybe I misread the decision.
That's possible. You may be right. I know she hadn't been deposed on this subject matter of this deposition. You may be right that in a prior part of the suit, she was deposed on a more limited.
That's what the judge said, that she had been deposed. It was as a result of her bad faith in not disclosing certain information or information that was discovered afterwards, that Lambert then concluded there was bad faith. So now we're going to expand the scope of subsequent depositions. And for my own benefit, how did it go from Sullivan to Lambert in the FOIA case, which are two different judges, if anybody doesn't know who those are?
I don't know.
Okay.
That's a short answer.
So, and now getting back to something you said earlier, which this was in the reasoning of the Court of Appeals decision to grant the mandamus to prevent the discovery. They said hold on, what did they say? There was two reasons. They said Hillary could show up, not be deposed, and then be held in criminal contempt, but not in a civil case, was one of the distinctions I think I remember reading.
That wouldn't make any sense. You can be held in contempt in a civil case, just like you can in any other case, and you have the right of appeal once a contempt has been issued or a sanction over a certain amount of money.
I'm gonna have they drew a distinction between civil contempt and criminal contempt.
Well, those are different things. That's true, but she couldn't be held in criminal contempt, but she could be held in civil contempt. So if anybody wants to see that, a federal civil case that I was tangentially involved in was the Joe Francis case in Florida, and they held him in civil contempt and then issued a sanction to try to punish him entirely. So, and that was all a civil case. He was not being held in contempt for a criminal case. So they have broad authority of contempt, civil or criminal. So while it's not a criminal contempt order, I mean, maybe they're saying a civil contempt order in certain contexts. Depending on how the civil contempt order is issued, it's not always appealable. But that doesn't mean it wouldn't be. And so that's where, I mean, so that there's that remedy. There's also just that's one remedy. Also, other forms of evidentiary sanction are available, and things of that nature. So that's where, like, the idea that it would have no remedy for her to be deposed doesn't make sense to me. And then secondly, it's also just very rare in light of what they're going to do in Flynn. But independent of that, I thought the basis for her to be deposed was pretty clear. I mean, this is someone who hasn't answered any of these questions about government documents that are subject to FOIA, and she's failed to produce them for years. And so the idea that somehow she's supposed to be, it makes the FOIA law look empty if all you have to do as a political official is just not store them on a government server, and then never answer questions about it.
That was one of the things they said in the decision, so Gary Herman says, no, the ruling said she did not have to be deposed. Okay, so I'll read through it anyhow. When I do a follow-up shorter vlog, I'll get clear on that question. They said that...
But you may be right. Now that you mentioned her being deposed earlier in the case, that may be right.
I'm fairly certain she was, and that Lambert came down on her because it was disclosed that she didn't communicate certain things. There were 39 discoverable documents that they did not communicate, and then when they discovered those, they said they hadn't complied with the initial undertaking. But what was I just about to say? The way the court of appeal, the panel gets around, they said, okay, well, yeah, you make a FOIA request. They just have to do a reasonable discovery, the reasonable search, and that satisfies their obligations. It's not. There was another act that they referenced which required a much more invasive search for the documents that were requested, but it was effectively just glossing over the bad faith, glossing over the non-compliance, and finding a way to get Clinton out of it, but not Huma. Was it Cheryl Mills or Huma Abedin? Who was the second one in that case?
It's either Cheryl Mills or, yeah, I think it's Cheryl Mills.
And so they said Cheryl Mills was not a party to the suit, so she doesn't benefit from the mandamus because she has other recourse. That was what they said. It was that because Hillary was a party, she did not benefit from the ability to show up and be held in contempt without consequence, and that was not a viable consequence. And therefore, the mandamus could be issued against a party to the suit, but not against someone who wasn't a party to the suit. She has available recourse to show up and not answer the questions, as if to instruct her to show up and not answer the questions and potentially be held in contempt, and then just go to court and have the judge say, yeah, those requests for documents was excessive, and we're not going to allow them.
Exactly. There's evidentiary sanctions. There's a wide range of sanctions. I'm not getting their logic at all. So at least what I can say for sure is people object to depositions all the time. They either don't appear, they object when they're there, they engage in bad faith conduct when they're being deposed, and I have seen contempt be used against them repeatedly. I've seen evidentiary sanctions be used repeatedly. So the idea that the only remedy is mandamus at that stage did not make much sense. Normally they only do that when it's like the president or somebody, like where merely sitting for the deposition is an interference or intrusion into another branch of government. That's not. She's no longer a government official.
I mean, I'm gonna go through the excerpts from this decision because it wasn't just that. Again, foregone conclusion. Just Google the judges, left or right. You'll know where they're going to go with the decision based on the subject matter, unless it's politically neutral subject matter. So I knew where it was going. I knew the way they were talking disparagingly about Lambert. I knew who he must have been appointed by or which party. Your experience with Lambert, is he a competent judge? Does he have
never been before Lambert?
Okay. No, so I mean, not knowing anything about him, they were just saying it basically effectively said his discretion, which is everything that the trial judge benefits from, his discretion was unreasonable. He came to ill-founded conclusions of bad faith. His orders were wide-reaching and broadened the scope of the FOIA application beyond what was initially requested, and therefore we're only left with mandamus 1 week after what happened in Flynn, or 2 weeks after what happened in Flynn. Question I was going to ask, I asked it sarcastically. Can not Lambert? Can someone ask for a full hearing on Ball now? Is that?
Yeah. I'm sure Judicial Watch will. Tom Fitton will, and I'm sure he'll try to take it up to the Supremes. It's just tough because it's seen as sort of a smaller scale civil case. So it's very rare they grant en banc hearings. And once they granted it here, and you knew the Democratic profile of the court, you knew which way they were going, and their questioning reflected that. I've never seen a 4-hour oral argument before. And the other thing I kept thinking was, what a waste of 4 hours, because I was like, there wasn't a lot of informative, path-breaking.
Got nothing new out of it. They barely even touched on the disqualification issue, which was, as far as I was concerned, the more legally intriguing discussion in Flynn. We'll jump back to Flynn. Yeah, it was. Look, I have two theories. I think it was deliberate to bore people out of watching it and being able to effectively summarize it. Much in the same way, I looked over the NRA lawsuit, 163 pages. For everybody who doesn't know, the Attorney General versus New York NRA lawsuit to dissolve them, 163 pages, 680 paragraphs. I said, forget it. It's the easiest way to deter anybody from looking into it is to make it verbal written diarrhea, so that nobody is going to take the time, because they cannot take enough time to do it. It's crazy. I think the 4-hour hearing was just a distraction so that people would tune out and not actually get concise points and questions of law.
And the sad part is this was probably the most publicly viewed, publicly listened to DC Circuit en banc hearing in American history. And what they heard was not a endorsement of the American judicial process.
Yeah, it did not. Look, I'm not judgmental, and I don't judge others just to feel smarter about myself. It did not. I was not impressed, and it actually was sort of discouraging. It, like I said in my video, it sounded like a congressional hearing and not a judicial hearing. It was the same nonsense I would expect out of politicians, not out of judges. Okay, now, so Ghost Crusader says, I was unsubscribed to you and I did not unsub to you. That is very strange. You are by far not the only person to have told me this in recent memory, but YouTube is YouTube. The question I had, so in Canada, I don't think we have, I might be mistaken, I don't think we have this type of review. Court of Appeal renders a decision. I don't think there's this en banc review in Canada. I'm going to feel very stupid if there is and I just didn't know about it.
I'm pretty sure it's probably not, because this is solely a function of the fact that we have so many judges. So in other words, for each circuit, we've got 10 to 12 active, another 5 to 6 senior. We appoint different ones by designation. So on any given appeal, you have a pool of 20 potential judges that are hearing a case. And so they created this en banc because of that reality. The circuit just comes from it used to be the U.S. Supreme Court justices, beginning of the country, rode circuit. Literally, that's where the circuit references. And so different Supreme Court justices would be responsible for different circuit reviews. And so we have, because of that historical precedent, the staff put certain things in motion that created this. Though as a whole, en banc decisions are extremely rare.
As in to say, they rarely agree to hear.
Yes,
they rarely. It's not like a pre-appeal to the SCOTUS. This is very rarely. It's sort of like, as I would imagine, is it less rare, more rare? On par with asking a judge to review his decision, like we saw in Sandman.
The short answer is the same as the Second Amendment case this week out of the Ninth Circuit. Flynn got lucky with the original panel draw. He got 2 of the 3 Republican appointees that could have heard the case on the DC Circuit be assigned. And because the rest, normally when you see political cases like this get taken en banc, it's because the panel's political profile looks very different than the circuit as a whole.
Okay, very interesting. Now, I'm not going to read this one out loud because I don't want to trigger anything with the YouTube algorithm. Let's go conspiracy analysts for a minute. Just Scalia.
I honestly don't have any idea. I've heard the various theories, but I don't have any knowledge on that.
All right, and now we got Nate says en banc is needed to overrule 3 panel. Yeah. Well, that's the question. It's just like, from a Canadian perspective, Court of Appeal rules. I don't know that we have a bigger Court of Appeal to say, now look at the Court of Appeal, and if you guys say something different, then we go to the Supreme Court. Like, it's Superior or Court of Quebec, Appeal, Supreme. There's not this really internal review process like we see here.
And by the way, that's true for most of the states within the United States. So most of the states don't have an en banc process for their appellate courts.
Okay, and we got Tommy Stewart. I think I saw this question earlier, so sorry, but honest question from an increasingly disillusioned citizen. Is there anything the average American can do to put a stop to the corruption? It's maddening to have to watch on a daily basis.
Be knowledgeable about it, expose it, and take what meaningful action you as an individual can do. And so it's the old answer, which is how do you deal with the problem of evil and the problem of evil people? Is you put more good and righteousness in the world.
I like that answer. I don't know what I mean, my answer is just try to do as much good as possible, and especially just try to give knowledge and not bias or not misinformation. And by the way, we just hit over 5,000 people watching, so that's freaking amazing. So what do you think is going to happen in the Clinton cases? So bottom line, Hillary does not sit for the deposition on September 9th. Someone correct me, is it Cheryl Mills or is it Huma in that case? I think it's Cheryl Mills.
I almost guarantee it's probably Mills.
Okay, so they remanded it to the judge, which means what in the context of this particular decision?
It means that no further deposition of Hillary takes place, and they can only depose whom else is available to them and get what other discovery they can. I think long term, what it means is what's been true of the Clintons since as long as they've existed is the Clintons don't face justice, and they won't here.
You think it's going to go to anyone? Oh, so you do think they might petition for an en banc review?
Well, I think Fitton will go all the way to the Supreme Court, but I just don't think it will be heard.
Okay. What else do we have here? This might be a good segue for what is Barnes' interpretation of Fokker and 48A?
Yeah, I mean, my view is the whole reason for this, the best analogy I do give is the judiciary would be shocked if the executive branch could drag a judge before a grand jury every time they disagreed with his ruling on the theory that, well, maybe his motivations were corrupt. Maybe there was a bribe. That was the problematic aspect of that whole hypothetical. The reason why we have a separate system to deal with that is if a judge was actually bribed, there's an investigation after the case, so on and so forth. What you do not do is try to interfere with it, try to use that as leverage to threaten a judge with criminal investigation because you don't like his case. The same is true of the judiciary. They don't get to threaten the prosecutor in the executive branch when they don't like the outcome of a case by doing an impermissible invasive inquiry. And so that's what Rule 48A is there for. Rule 48A is there for that person. Fokker recognized that. I believe it was Siri. I'm giving this short version of his name.
Srinivasan.
Srinivasan. Man, there's no way I'm getting that right. Too many vowels. I used to my friend next door who was older than me when I was a little kid. I always called her Verne. It turned out her name was Renee the whole time. I found that out like when I was 25. But certain things can't do, so I don't try. But I believe he was the one who actually authored the Fokker decision. Whenever I see Fokker, I think of Meet the Fockers. So I have a hard time keeping a straight face on that name of that decision. But that in Rule 48A, its purpose was that prosecutors not to circumvent and abuse a defendant's rights. It's not meant to be anything beyond that. It was not a rule that was meant to somehow breach executive privilege and executive discretion about prosecutorial declination. There's no evidence for that whatsoever, and that it goes right against the constitutional separation of powers. And I do believe that if Siri's not careful in what decision he issues for this case in Flynn, the Supreme Court may take it. And if he gets the Supreme Court to slap him down, he can say bye-bye to his Supreme Court future, because a lot of political officials will remember this. So if he's smart, he'll do a compromise outcome that doesn't unduly agitate or upset the Flynn folks. But we'll see if he's as politically savvy as some people think he is.
All right, amazing. Far Stepper, we're going to be talking about Millie Millennial tonight, or Millie Weaver, as I now know. Sakake Onse says IIRC. What does IIRC mean again? I always forget that. Most of the circuit courts have finally been filled. District courts still have a bunch of vacancies. Think they could be filled before November 3rd?
Not likely. McConnell's trying to push through a bunch, but I don't think that will happen. But that doesn't mean they won't be pushed through by January 20th, even if the presidential election flips.
And Jason L says this is a good segue. Sorry, I just took it out. Last question. Real honest chances Snowden gets pardoned. They won't allow it, right?
If Trump is serious about, Trump has always said, he even said this at Liberty University, no less, which is a very, conservative Christian school. He said, never forget to pay back your enemies. And if he's serious about that, if he wants to deal a real response to deep state politics and power, then he will pardon Snowden and Assange. Here's what I think is going on. I think both the Durham investigation and the Trump's talks about pardoning Snowden are an attempt to create a with the deep state actors who tried to take him out in 2016 and 2017 and 2018 and 2019, that they should back off and not interfere in the 2020 election. Or if they do and he loses, he'll start pardoning everybody they hate. So and Durham will escalate and bring more indictments against more people. So that is a good segue into really all of this both gives context to the Flynn case and context to the Millie Weaver case, the context to the Klein-Smith Spygate case, and broader context and context even to the Hillary Clinton case to a certain degree, which is that is a sort of backstory. So the backstory of how intelligence operators operate. If you want to understand American politics and how it operated, and this used as a template by international operators post-1970s, is the American Tabloid trilogy by James Elroy. So the first book is American Tabloid, the second is The Cold 6000, and the third is Blood's a Rover. He always said these were history books, that if there was an honest librarian, they would put his fiction tales in the history section. He does a great job of giving a template for how American power operates. It also actually is good context. The Last Narc that we talked about last show is good context for this. The Felix Rodriguez's of the world, the Frank Sturgis's of the world. People want to Google Frank Sturgis, then they'll understand what I'm talking about. Just look at the peculiar places this man manages to show up, from supposedly being with Fidel Castro. Well, he was with Fidel Castro in the hills in Cuba in 1958 to being one of the arrestees at Watergate. How does that happen exactly? So the key is that the international operations of the spy, national security state, whatever you want to call it, deep state, anything else, effectively integrated a lot of outside operators and outside contractors, the industrial military complex that Eisenhower talked about in his exit speech in 1961, his farewell speech. And what it is just institutionalized intelligence apparatus in the United States. And because of the disclosures of MK Ultra, by the first famous burglary and disclosure of documents, of course, was to some degree it was the Pentagon Papers being leaked. The second one was the robbery that took place in Media, Pennsylvania, by a small group of people who figured out that small FBI office was not really well protected, burglarized it, and they're the ones who first disclosed COINTELPRO. That later led to the uncovering of the other issues that were pertinent in terms of MK Ultra and other illicit activities by the FBI on domestic spying and surveillance in the United States. All of that led to the Church Committee hearings, which led to the exposure of a bunch of corrupt officers within the broader national security state, including at the CIA and other places, including the prosecution of Mark Felt, who was a Hoover director of COINTELPRO, who was the secret source for destroying Nixon. Deep Throat was actually one of the most corrupt agents in the history of federal law enforcement, who wasn't doing it to clean up government, but to protect the most corrupt aspects of it. And they were cleared out by Carter in large part. Many of them end up showing up in the Iran hostage issues in 1979, 1980, and will show up in other contexts. But what happens is our intelligence infrastructure started to outsource. So they started, and that's what Millie Weaver's film was about. That was about to be released when she was suddenly arrested, she and her husband, on Friday. They were going to release this week a documentary called, I believe it's called Shadowgate. It's up, currently still available on YouTube. We'll see how long that lasts. It's up on band.video as well. It will stay there forever. And basically what it just details is this overlap between outside contractors and the national security state, and how it is compromising intelligence and creating a deep state that has power outside of the institutional roles of government. If you want to see a good TV show that sort of covers this in live time, it's a show called Deep State. It was either on FX, I think it was on FX, maybe Epix, may have been Epix, but it was actually pretty good. I think it went through 2 seasons, maybe 3. But it just documents this overlap between the outside contractor world and the national security state at the highest levels. And that's who was called upon to go after Trump in 2016. So it wasn't the Defense Department internally. It was outside contractors being paid by the Defense Department, people like Stefan Halper, who are longtime operatives, who are often located in think tanks, foundations, university professors, sometimes within the media. You can study Operation Mockingbird for how that was done at full scale. It partially portrayed another great movie called Spy Game, where one of the Hong Kong reporters is really on the UK spy payroll, and that helps facilitate certain things that takes place. And so all of that, the backstory is you've had outside contractors have had extraordinary access to a bunch of government secrets. So that's part one of what's been happening is sort of backstory. The other second part of what's been happening is backstory is the centralization and digitization of information. So, back in 1971, they had to actually break into an FBI office in Media, Pennsylvania to get the files because there were only hard copies. When Hoover died, when they looked for his files, almost all of them had disappeared in ways that nobody has yet been able to understand, all of his internal blackmail files. But now the digitization of records transforms that entirely, and particularly with the information gathering expanding dramatically. So not only does the NSA, here's one of my little favorite trivia questions I like to ask people: did Ed Snowden receive a W-2 from the government at the time he went whistleblower? The answer is no. He was working for an outside contractor. How did an outside contractor have that much access to every single piece of intel about every single American? That gives you the scope and scale of what's been taking place. Not only are records accessible now electronically, which changes who can access them, changes how easily they can be accessed. It also, the scope and scale of what's being gathered is unprecedented. This was combined with Obama digitizing medical records under the Obamacare Act, which the IRS was using as a pretext to gather medical records on every single American. The blackmail, I was involved in that because I brought the biggest Bivens class action in American history against the IRS after they seized 60 million medical records of 10 million Americans, including prominent federal judges, including almost every Major League Baseball player, almost every member of the Screen Actors Guild, the Directors Guild in Hollywood, major press participants. They knew, who went to what kind of sex therapy, who went to what kind of drug therapy, who was on illicit drugs of different types. I called it J. Edgar Hoover's wet dream of a blackmail file. They were gathering that in mass, and my client blew the whistle on it through our suit, which prevented it from going further. But that gives you an idea of what they want. So in that context, Millie Weaver's making a film about how this whole shadow world of outside contractors have incredible access to blackmail files based on their ability to be part of this extended deep state operation that's now not only national, but international in scope. Then at the same time, you have Flynn, who's sort of a critic of the certain aspects of this, of the national security establishment, who wants to purify it from its rogue actors who they needed to take out. And to give you an example of this, the outside contractor for the Defense Department helping to set up Carter Page is Stephen Halper. Stephen Halper came out this week, actually told people 3 days before any Flynn story broke that Flynn was going to be taken out. So that gives you an idea of the overlap of what's happening here. And if you read a James Ellroy novel, well, that's in the domestic context, you'll understand how it applies now in the international spy context. Then you add to that movies like Taylor of Panama, Our Man in Havana, and you get a bigger context of spies often just make stuff up. They're illicitly connected to enrich themselves often. They cash out in the private sector. Just track where high-ranking national security establishment people go. Where does a John Poindexter end up? Where does a James Comey end up back when he left the first time? How does it overlap with cases that Mueller's handling at the same time? Where does John Brennan leave? Which company? And it's always companies that sound like CIA front companies, like the Analysis Corporation. I always tell people, if you want to hide assets, or if you want to deal with asset protection in general, if you want to watch how the CIA does it, it's always the worldwide imports. It's always some generic name that there's 600 versions of, so you can never track and trace who's doing what where. So all of those, so that's the sort of broader context of what's going on. And then you put into another context, the origin of the CIA and itself, which is that the CIA was really created to defend a certain class interest, and that they disguised as America's interest. But the CIA was the original predecessor of that was the OSS, Office of Strategic Services. They were formed by, when I was at Yale, I wrote an article about them because there's two statutes to Nathan Hale in America. One of them sits at the center of Yale's old campus. The other one sits at the center of the CIA campus. It was three guys at Yale who helped form the foundation of the OSS, the CIA, and the State Department's intelligence apparatus. Particularly the Dulles brothers were heavily influential in this. And they believed that what was good for GM was good for America. What was good for the United Fruit Company was somehow what's good for America. What's good for gold miners is what's good for America in South Africa. What's good for diamond miners is what's good for America in the Congo. And a lot of their policies and politics that were supposedly about American interest and anti-communism were almost always about protecting an elite class's interest. And almost all the CIA recruits from Harvard and Yale and the Ivy League. It's not a coincidence you keep seeing these young kids pop up from the Ivy League. The lead whistleblower in the Ukraine case, a young Yale graduate. A key person that's involved in giving info to Steele was a young kid working at the Brookings Institution. Stephen Halper is an old professor. They all intersect, who often teaches at Oxford. So in Cambridge. So that's where a lot of these, it's really an elite class protecting itself. That's how they see it. That's how they see themselves. And they use the Hoover tactics of the 60s and 70s in the modern era to gather information and protect their self-interest. So to them, Trump was a direct threat against their self-interest. And in leading into the Kleinsmith indictment, the problem was, how are they going to be able to use their outside contractors, share information selectively internally that you could never do if it was a criminal grand jury investigation, yet at the same time have all the power of a warrant? Well, you call it a counterintelligence investigation, and in order to share information that you otherwise couldn't if it was a grand jury investigation, and you use FISA. And so you say it's a Foreign Agents Registration Act violation rather than a grand jury investigation. So you can circumvent all the controls the judiciary has, the legislative branches have on this process going AWOL. Now, so that's part of what's going on. The second part of what's going on is they had to make up a story. Their problem was anybody who knew anything about Trump knew the idea of the Russian blackmail story was just absurd. The story was ludicrous on its face. So if you're Chris Steele, you're just Taylor of Panama, you're our man in Steele, you just find all the rumors and innuendo you can over conversations at bars with people who have no connection to anybody, who've just heard rumors and innuendo. The crazier you make it, the more believable it is to the people that are paying you and wanting to propagate it. And that's how you launder intel and information there. You create bogus sources. You claim you're a secret spook that has all these connections when you don't. That's step one. But within the government, they need to be able to tell a story to get access to FISA. And the key was, how do they do that? They had nobody connected to Trump that would legitimate an extended FISA warrant. So what they do is they look at Trump does a interview with the Washington Post, and the Washington Post demands to know who his foreign policy advisors are. Truth is, Trump's just going on his own instinct. But so the campaign just comes up with a list of anybody who's ever sent him a letter. And included in there is Carter Page and George Papadopoulos. So they do a long-scale, basically entrapment campaign against Papadopoulos, but that takes time. So they try to set him up in multiple locations, in multiple honey traps, multiple bogus meetings. They misrepresent what he said, all of that. Then the second thing they do, parallel there too, is try to get a FISA on Carter Page. Their problem is Carter Page is an honors graduate of Navy and has been a source for the CIA going all the way back to the mid-2000s, because he ended up in Russia for doing economic energy development out of the UK. And so he was one of the few people that the Russians would often approach, and he became a CIA source. And he would meet with Russians he had no interest in meeting with, solely because the CIA wanted him to do it. They did the same thing to General Flynn. Flynn went over to a dinner in Moscow where Putin was at the table. He only went because the Defense Department asked him to do it, and he was going to come back and report intel on what he could find. So and Putin likely knew that, didn't care, but he was trying to pitch a détente with the U.S. on the united ally of radical Islamic terrorism, which is a major problem in Russia as well. So and not have a repeat of Libya. So that's what's happening. How do they make that look bad? Well, just as they lie about Flynn actually reporting to the Defense Department and try to make that look bad, and the media's lied about that now for years. Oh, look, he's over with Putin at a secret dinner. No, he wasn't. That doesn't what happened. But the other part is they had to lie about Page, because how do you get a FISA warrant? You're like, oh, this Carter Page guy, he keeps meeting with secret Russian agents all the time, going back a decade, right? How do you make it sound that way when, in fact, he's doing it at your government's behalf? you lie about the fact that it's at your government's behalf.
So this is interesting. Now, this is coming back to the one thing that I didn't fully understand is in the, the news is reporting that, or the big issue was that they reported that Carter Page was not a source. This was in the application for the FISA warrant, correct?
Exactly. So what happens is they lie about it in every FISA warrant. Finally, somebody in the process realizes we need some CYA. This is after Trump has won in 2017. So they're like, get the CIA to send us an email saying he wasn't a source. By the way, I have no doubt that everybody high up knew he was a source. So Kleinsmith is the fall guy. They tell Kleinsmith, hey, make sure you get that confirmation for us. Wink, wink, nod, nod. Kleinsmith says, oh, okay. But of course, the CIA isn't playing ball anymore because Brennan's gone. CIA responds, and also Carter Page has been a very useful source.
One interruption. Kleinsmith is, he's a lawyer, but what's his official function in government?
So what I call the deep state are people that are in high-ranking positions in the National Security Division of the Department of Justice, the Counterintelligence Division at the FBI, the intelligence attached to the State Department and the Defense Department, and in the CIA, and certain people in NSA. But the people in NSA often are not involved in the same way. That's handled in a different manner. They're mostly data gatherers more than they are sharers. They let the third-party operatives do the outside contractors do a lot of the illegal spying work. And so they can have plausible deniability on the NSA side. The other guy to talk to on this, of course, is always William Binney, who has great, fantastic, the true original NSA whistleblower. Page made clear to a range of people once there were inquiries that, yes, of course, he'd been a CIA source and that they knew. Now, he didn't want that published at the time. Now it's published to the world. Because that was, so much for doing any future business in Russia when that's now a known public fact. And so that's why they put him in a bind, right? So this is why initially, even when these smear stories are coming out, he can't really respond publicly. He can't say, "Oh yeah, no, I've been an informant against the Russians for years," right? He can't say that. So that's why they knew they had him in a double bind. So, but within these apparatus, one of the key, so you're looking at people that have that label next to them: national security at the Justice Department, counterintelligence at FBI, or certain intelligence assignments at the Department of Defense, or the National Security Agency or the CIA. So Kleinsmith was the deputy general counsel for the National Security Division at under the Justice Department, often working together with people at the FBI. And so almost any FISA warrant would go through someone like him. And so, but he was of the group on that list. He's beneath Yates. He's beneath, definitely beneath Clapper and Brennan in terms of their independent roles on that side of the equation. But within even the Justice Department hierarchy, he's beneath Yates. He's beneath Rosenstein. He's beneath Bente. He's beneath Comey. He's beneath McCabe. You could say he's kind of beneath Strozik, and Priestap and Lisa Page, and James Baker, general counsel of the FBI as well. So, but he's high up relative to the rest of the world. He's low up relevant to that group of co-conspirators. But Kleinsmith is the supervisory special agent who they haven't identified yet, but I can't believe that this wasn't coming from Strozik. Is basically saying, hey, Kleinsmith, we need this third request for an extension of FISA. This is the third time they were spying on Trump even during the campaign. While he was president. It's the third. Is it the third request or the third renewal? Third renewal. Okay. So the key is for FISA warrants, for people to know, Foreign Intelligence Surveillance Act and the Foreign Intelligence Surveillance Court were created to stop spying on U.S. citizens, to give you an idea. So they only come about in the late 1970s. The Frank Church was the first United States senator known to be spied on by the National Security Agency. In 1974, a reformist Congress comes into power because of Watergate. And consequent to that, they form the Foreign Intelligence Church, creates its own special select committee on intelligence, which sadly became a permanent committee owned by the intelligence community. But at the time, Church exposes assassination plots, COINTELPRO, MK Ultra. Only reason we have any hearings on any of this is because of Frank Church and because he was still ticked. He was, I think, a Democrat from Idaho back when they had Democrats from Idaho, who was still mad about getting spied on by the NSA. And so when he got power, he was like, I'm going to have a little fun. And he did. And from it, they created a law. They discovered that they were using the guise of spying on foreigners to actually spy illegally on Americans. So he said, we need to stop this. So they created the Foreign Intelligence Surveillance Act, the Foreign Intelligence Surveillance Court, special appointed court by the Supreme Court Chief Justice, now Justice Roberts. And the whole point was stop spying on U.S. citizens. You have to get judicial approval before you do any kind of spying like that that touches on U.S. citizens. You have to meet a very high threshold. People may remember back when it was originally came out that these warrants existed, they said, well, that means that it has to be true because these warrants meet every high-ranking official has to sign off on their authenticity. And now we know they all signed off on false affidavits.
On crap. And now, and so just to understand, like the one thing, first of all, Kleinfeld, so he's high up.
Kleinsmith.
Kleinfeld is the lawyer from Carlito's Way. Kleinsmith, he's a young lawyer. Is it I don't want to say like use the terms like a fall guy. Is this just a young schnook who knows what he has to do because he knows what people want, and so they're going for the third renewal and they have to make these meetings between Carter Page and Russians look more suspicious, so they scrub the fact that he was what's the word I'm looking for, not an asset, what's the word I'm looking for,
a source.
A source, sorry. So they scrubbed the fact that he was a source to make it look like he had no legitimate reason to be meeting with his Russians so they could get a FISA warrant.
Yeah, so I would say two aspects with it. One is they've been lying about this all the way through. The difference is they had not even made the attempt to sort of paper the file. So when they did warrant request number 1, warrant request number 2, they're lying about Carter Page. The way FISA works for everybody to understand, the Sally Yates tried to lie about this. Just a reminder, Sally Yates is corrupt, eternal truth. Right there should be Genesis 1. Genesis 1 should be added, so they add a verse to it. But what they did is in order to get a FISA warrant, you have to meet a very high standard that someone's illicitly spying on the United States, effectively, if they're a United States citizen. Secondly, the warrant has limits of time, usually 90 days. Because they don't want, again, they're worried about abuse of authority on this. The next part of it is now, here's the power of a FISA warrant that's very unique. Not only is it outside of traditional judicial controls and protocols, but in addition to that, and separate from that, and doesn't have the same degree of legislative and traditional judicial oversight that would be present, but it allows what's called a 2-hop rule. And what it allows you to do, and it allows you to go back in time. Your typical warrant is, I get a wiretap for future communications. Not a FISA warrant. A FISA warrant allows them to look 6 months back and look at all of your communications going backwards from the date of the warrant, not just going forwards for a 90-day time frame. The second thing it allows you to do is what the 2-hop rule, which is, let's say I want to spy on Hillary Clinton. Well, I know I won't get a FISA warrant on Hillary Clinton. So I look at maybe John Podesta, campaign chief of staff, but I know Podesta, too high profile, it's a problem too. So instead, I choose Sidney Blumenthal. Because Sidney Blumenthal communicates with Podesta, communicates with Hillary, a FISA warrant on Sidney Blumenthal allows me to look at all of the emails and track records of Hillary Clinton. That's what a 2-hop rule does. So that's the incredible power of a FISA warrant. And they were not interested in Carter Page. They had zero interest in Carter Page. The whole goal was a Carter Page FISA warrant allowed them to spy on the entire Trump team because Page had been in contact with them at least within 2 hops of everybody on that team. It also allowed them to go back. So when Sally Yates was like, Carter Page wasn't part of the campaign anymore, that was such an obvious lie that if Lindsey Graham had any form of spine, he would have followed up on himself. Ted Cruz, to his credit, did. But Graham tried to exculpate her. So going back to Kleinsmith is high. Now, Kleinsmith is a political activist. His own, just a reminder to all the would-be criminals out there, always in writing, never in cash. I mean, never in writing, always in cash. Never in writing, always in cash. The apparent rule, but these dimwits, Strozik, Lisa Page, and now Kleinsmith, is that he was dumb enough to text on his FBI phone. and this is deeply ironic. The guy doing a FISA warrant because to get other people's texts, knows how incriminatory they can be, is busy texting things like "Viva la Resistance." Right after Trump won, he said, "I'm so depressed. My name is all over the Trump paperwork." So, by the way, there's a giveaway that was a Trump investigation, not anything else. So Kleinsmith is part of the young professional class, and there's been a class political change in America since I kind of blame it on the West Wing show, but the whole political class in DC, I was there as a kid watching it happen, 18, 19 years old, working as a summer intern in Washington, DC, freshman year after Yale. And I saw in West Wing had started to become popular around the TV show, and it popularized being part of the political class, being an advisor to the president, being an advisor to a congressperson, being an advisor to the Senate. So rather than these being old school political prototypes who came often from blue collar middle class communities who were part of the administrative apparatus in Washington, increasingly it became the credentialed class that monopolized those jobs. And so the professional class as a class has strong cultural and political biases. They have incredible influence in Hollywood and media and universities and all of our culture shaping institutions. But they also almost dominate all the professional political consultants and almost everybody who works in DC. So the professional class hated Trump. And this guy was a member of that professional class that hated Trump. So he personally hated Trump, wanted to see Trump beat. So he was personally motivated. He was a happy co-complicit party in this co-conspiracy, but there's almost no chance he would have the guts to do this on his own. The idea that he by himself manufactured this, and dimwit Andrew Weissman, that hopelessly corrupt prosecutor who's now finally outside of the Department of Justice, has been tweeting away about how Kleinsmith clearly wouldn't have done this on his own. He somehow thinks it's a defense for Kleinsmith. And what he's not realizing is, I agree with Weissman, Kleinsmith didn't do this on his own. Someone instructed him to do it with a wink and a nod. What somebody wanted was create a bogus paper trail so I look good. And that's what Kleinsmith did.
I'd say it's an amazing, it's something I said before, like the corruption, never in writing, always in cash, but oftentimes it's part of a desired outcome. They know what they want. Nobody needs to tell them what to do. It's understood, or you say, in the subtleties, yes, what needs to occur. So my understanding now, it's totally amazing. Some people are saying I look dumbfounded. It's putting pieces together. The two-step process, they're only going after Page through a FISA warrant, so they can go 6 months back on all of his texts and correspondence, indirectly survey those who they could never get warrants to survey in the first place. And the way to justify the third renewal is make Carter Page look more suspicious than he actually is.
I think what happened there is they'd always been making him look like he was a Russian spy going back. They got nervous in this middle of 2017 because they knew they needed to paper the file. Mueller was investigation. By the way, Kleinsmith is involved in the Hillary Clinton email investigation cover-up and the Mueller investigation and the Russiagate components. So, that gives you an idea for how a small group of people could manipulate all of this.
No, I forgot. I'm still shocked about how it's the same freaking judges coming up in all these decisions, and they're all sleeping with each other, proverbially speaking. It's a small incestuous world that sets the precedent for the rest of us.
And then what is they're defending their class interest, their professional class, elite class interest that President Trump threatened in ways that no presidential candidate ever had. But what's happening is summer of 2017, things are starting to break differently. So they start to become concerned that they need a better, it wasn't that they were enhancing Carter Page's risk, is that they needed to paper the file so that all the false statements they've been making about Carter Page looked better than they were. So I think what happens is somebody high up says, okay, we need something on here, like a document from the CIA that says he was not a source, that even though we never asked him for that intel, likely because we knew otherwise back in 2016, we now need some bogus cover story. And their problem was Brennan was no longer in control of the CIA, so they no longer had the cover story from the CIA. What Kleinsmith was supposed to do was get a CIA person to lie to them and create that fake paper trail. Instead, of course, the CIA didn't do that. And so then Kleinsmith was stuck, and he's like, okay, what am I going to do? I'm going to have to fake the email. And if I just fake the email, then we'll have a paper file so that the higher-ups, if anybody looks at the file, they can say, no, look, we had every basis to believe Carter Page had never been a CIA source. CIA told us so.
Unbelievable. Unbelievable. Okay, now Robert, I'm going to give you a rest give me 5 minutes, everybody, because I have been missing a ton of super chats, and I don't want to be discourteous to the super chatters. I can't bring them up anymore, but I'm going to read the names. Vicky Rose, and we may not be able to answer the super chats, but we're going to do this and then break into. We have two more subjects. We got the high capacity magazines, and we got to do the Millie story proper. Now that we've had the massive backdrop of all of this. Vicky Rose, understanding subpoenas are invasive, e.g. electronic communications. How do prosecutors account for invasion of privacy for not only defendants, but for other people within evidence collected? Do any rules or regulations apply? I mean, I guess the idea is if there's anything that concerns third parties, it can be filed under seal. It can be redacted if necessary. But
it's why wiretaps are very hard to obtain. So to give you FISA is just an absurd exception, and it's meant for high-end terrorism emergency risk cases. That's why they're 90 days. The idea is that you only go to the FISA court when we've got an imminent plot. We need to know exactly what's going to happen. It may happen within days. We need this authority. And that's why they're a rubber stamp, effectively, because they always think that's what's really happening. Now, their eyes should have percolated up when anybody connected to Trump was being investigated. But the FISA court, Roberts puts people on there who are deferential to the executive branch, so they never second guess them, never question them. And I don't blame that just on Roberts. Every Supreme Court justice has done that. Chief Justice has done that. And occasionally you'll get a FISA court judge who will get upset and issue one of those. And every 4 or 5 years, you'll get a FISA court order that says, "I can't believe that you guys have been lying to me for years." It'll just be one of these.
Yeah, that's another one of the cover your ass judgments. Like, you've been lying to me. How dare you? You make me look stupid. Nuts.
And remember, originally they orchestrated General Flynn's plea to be in front of a judge who'd sat on the FISA court who was personal friends with the corrupt special agent. I mean, it keeps going on and on.
I brought that super chat. Someone says, "Yeah, the worst is Rudy Contreras, who was texting Stroke or joking about his relationship with Stroke, who was the original judge on that file."
So, but going to that question, if let's say you want a wiretap, the IRS, for example, no wiretap authority, because even Congress knew those dimwits don't need any that kind of investigative inquiry. So now they have the ability to go through your tax records, which is a confession of all kinds of things. Which reminds me of a good book called The Confessions of an Economic Hitman. If you want to understand the interrelationship between non-governmental organizations and deep state apparatus, it's a very good book called The Confessions of an Economic Hitman. But in order to get only certain agencies can get a wiretap. Judges are generally skeptical of wiretaps, and usually you have to say on the wiretap that if the conversation, you can only listen for a little bit. The conversation isn't continually about the subject of the wiretap. You have to opt off.
Yeah.
You can't keep recording.
Good luck.
That's not true in FISA. So in FISA, they gather the NSA is gathering. In case people don't know, this is why Trump was threatening Snowden. It's not a coincidence he started talking about Snowden right now. He's agitated about the lack of action by Durham in part, and he's wanting to deter deep state actors from trying to undermine, doing an October surprise like what they did to Carter with Iranian hostages, and take him out in the general election. So he's playing a cat and mouse game, and he's playing a little bit of a what's that game where you have two cars going at each other and who's going to chicken. He's playing a little bit of a game of chicken with him. That's why because Snowden is the guy who outed all of this in terms of the corrupt surveillance, how broad it was, how wide it was, how it involves outside groups, how it's not being limited. All the abuses they used against Trump were originally documented by Snowden. So a FISA warrant can look at everything. By contrast, when you get a wiretap, or let's say you get a search warrant, or you get a subpoena for certain records, those records have to be limited. You have to request it be by category, by time frame. You can't look at certain records. If you illicitly look, I've brought this up in multiple cases. Whenever they look at records they shouldn't, I go after the agents. I go after the prosecutors. I go after the whole case because they gathered intel they were not entitled to. That was an invasion of privacy. That can be a Bivens action against the federal government, a 1983 action if the state government does it. So there are limitations to protect privacy outside of the FISA context. FISA is the one place where there really is no protection for privacy. And the protection is supposed to be the super high probable cause for these very rare cases of very rare instances of someone involved in foreign spying on behalf directly of a foreign government. Carter Page, that was all absurd. Patently, I mean, the FBI was so bad, the FBI did something it had never done, which was formally withdraw those from the file. and say they never should have been filed and were never had any factual evidentiary basis.
Too little, too late. What's
yeah.
mind-boggling is that I'm still going to have an argument with people who think that there was nothing fishy about the FBI investigation to Trump.
People used to. I remember having a debate with someone during while I was representing Wesley Snipes, challenging the city of New York trying to do a forcible DNA extraction while rummaging through his personal information. And she's like, "Well, if he's not the father, he'll be happy to take that test." And it was a general privacy argument. And I said, "That's fine. You know, I think you might be up to something bad in your bedroom. You don't mind if we videotape it, right? They just in case. I mean, you know, it's like everybody has some limits to where they recognize certain privacy should be protected. And if people have no problem whatsoever with this kind of FISA investigation, then just open up their home to 24/7 internal taping, tape record every conversation, tape record every activity. There's very few Americans who are willing to actually do that. It's mostly political bias that explains their reasoning in these cases.
Mm-hmm. Well, I'm sure there are apps for that, which I'm sure is coming in. Okay. John Christopher says, so Viva still want to become a U.S. citizen? I'm happy being Canadian. I say everybody loves their home, even if they love it for their foibles or for their problems. Canada has some issues. It's still my country and my home country, and I love it. Tracy Copeland says, what kind of soda is RB drinking?
Yeah, so this is Zevia. So this is a great thing of the BS nonsense that takes place. Let me see if I can get that right. There, I'm not terrible at it. Yeah, there we go. Finally,
notice it.
I like black cherry because it's particularly good with cigars. So it's my favorite one. The advantage of Zevia is made from stevia. And to give you an idea of how corrupt the government is, the sugar lobby prevented stevia is a natural alternative to sugar made predominantly in Brazil. It has almost none of the bad health effects of sugar. And yet for 10 years, the FDA held it up and wouldn't allow it into the United States. And the reason it did so was solely to protect the sugar lobby, because instead of these aspartame and these other sugar substitutes and other drinks, they can mess with your brain. There's evidence out there that raises questions about whether they could cause brain cancer, other things. I don't know what the final conclusions of those studies will be, but all I know is when I've drank them, I get headaches. So the great thing about stevia is it's a completely sugar alternative that's healthy and natural and organic, not made in some lab somewhere.
Do you own any stock in stevia, the drink you're drinking?
No. I own no stock in anything. I'm not a big believer in the stock market. Years ago, I used to play around the stock market, made a little money. I just bet on whoever was the greediest thief that I thought. So I thought Bill Gates, good bet, Bezos, some other people. But at the same time, I finally dawned on me. I was like, I'm never going to have the same inside information that the big players have. So I'm always going to be on the outside. I can make a lot more money sports betting in terms of investing than I can in political betting than I can in the stock market. And I became questionable about the core. The stock market started to get disconnected from the real economy in ways that I thought maybe they can magically, artificially keep it up for decades, but there's not a lot of history behind that. So that was the second reason I opted out. So I own no stocks of any kind. I think there's some 401k I have from some prior employer. I pay no attention to it. So.
All right. And Forrest Stepper says, I live in America and I'm terrified at the fact my friends around the world has no idea what is actually going on here. It has been almost 80 days of riots. Can I legally protect myself from rioters or censorship? Please answer.
Well, that gets a nice bridge to the Second Amendment. So the Second Amendment case is the best way to protect you. First Amendment should protect you from state censorship. It unfortunately does not yet protect you from these private companies that have bought up the public square. I think it should, but right now it doesn't. The courts are effectively closed to it. But in the Second Amendment, great case out of California. What happened was California, and what happened was the panel, 2 Republican judges, 1 Democratic district court judge sitting by designation.
Let me interrupt you. I thought it was a unanimous decision. And I'm just going through the judges. And I see, 2 Republican, G.W. Bush and Donald Trump, and 1 Clinton. Yep. And then I'm reading through the decision, and sure enough, it's a dissenting is Clinton, and the 2 Republicans go the way of Second Amendment protection.
Yes.
And incidentally, Toby Warren also had a super chat on this. Your thoughts on the Ninth Circuit overturning high-capacity band magazines. So fill us in.
Yeah, exactly. So there's effectively the California has all kinds of crazy gun laws, but the latest one was they attempted to ban any magazine with 10 or more bullets in it. Well, that's how they defined high capacity. Mm-hmm. Well, of course, by that definition, I mean, here's the thing that's always been true. Democrats are thinking, well, you know what? Maybe we can't ban the gun. We'll just ban you from owning bullets for the gun.
Chris Rock had a good bit on that. He says, like, don't ban the guns, just make it cost $5,000 a bullet, and there you have your problem solved. When you want to do something bad, you're going to go get a job, put it on layaway.
They're doing the exact same. That's what they're doing. They're just doing the legal scheme. So the court, I recommend people read the opinion because it's got a lot of great history to it. I like cases that go through a lot of the legal and political and actual cultural history of the country. Of course, the left remains completely uninformed and uneducated. Oh, by the way, this is a Cohiba special edition. It's a rare limited edition for this year. They only made, I think, 1,000 of them worldwide. Someone sent them to me, and so they're very expensive. They cost about $200 a cigar in Europe. Because of Cohiba will take the best of their tobacco from that year and make different limited special editions, and sometimes from multiple years, and they'll put their best rollers on it, and it creates an impeccable cigar. Still not as good as the Davidoff Cuban cigar that Charlie Sheen gave me a few years ago. So that's why I have nothing bad to say about Charlie Sheen. Gave me a great rare cigar. It's unavailable. So always nice by me. So I don't know. Everybody else got issues with him. I don't. Nice guy by my book. We had some fun little political conversations in his back porch. The Second Amendment issue is that they ban the magazines. They go through the great history in the whole case, and the case details how, in fact, magazines of this size, of having a revolver or some form of it that can shoot 10 or more bullets and shoot them back to back to back, have been around since the 1600s in some form or another, and they were here at the time of the founding. That's not necessarily a legal requirement, but it is pertinent. It is over half of the guns owned in America have the magazines that California banned. And not only California banning you from purchasing them, they banned you from possessing them. So you had to return them if you had them. So the point was they were banning half the guns in the state, half the guns in the country, critical, essential for those guns to be functional for self-defense purposes. And that's precisely what the Second Amendment defends. And that they did not get anywhere close to meeting a strict scrutiny standard for why they had to ban 50% effectively of legal methods of gun ownership in America.
Okay, so now... And so just so everybody appreciates that, it was a ban on high capacity magazines, which were defined as over 10 bullets. I don't know if it was 10 or more, 10 or more or over 10. And effectively, I didn't know that except from reading the decision or the article summarizing it. It included 50% of magazines in the United States.
Yes.
So
it's like the Beretta.
Yes, I know nothing of this, but it was all interesting to learn. Now, the strict scrutiny versus the intermediate scrutiny, which was the big milestone apparently of this decision. Do you want to explain to people what the difference is between intermediate scrutiny that was hitherto applied and the application of strict scrutiny to these types of constitutional infringements, I guess?
Yeah, exactly. So really, I mean, I think strict scrutiny should apply to almost everything, but the Supreme Court has created these crazy in-between standards. They have rational basis review, intermediate degree of scrutiny, and then strict scrutiny. That's the three main standards they usually utilize. Essentially, the difference is what right is being violated. So if it's a core fundamental right, they sometimes call it a core right, sometimes they call it a fundamental right. They'll call it different things at different times. But essentially, if it's a core constitutionally protected right, then a state limitation on that right or intrusion or invasion of that right usually has to meet strict scrutiny unless they say that the state is only slightly or lightly burdening the right. I don't like a lot of these. These standards are inviting politicized judgments by courts to give. I'll give an example of this in the political context. There's a guy named Professor Lichtman who does a model that predicts presidential elections. I've long criticized his model because I said it's prone to highly subjective interpretation, that if you don't have really objective determinations and something that is empirically rooted, that can be factually checked, then it's up to the eye of the beholder what a word means. So in the Lichtman context, he says he has these 13 keys. And one of the keys is if there's been a scandal, a major scandal, then the incumbent will be a factor for him losing. We'll define major scandal. According to Lichtman, Benghazi, Tea Party, giving guns to Mexican drug cartels, all of these things were not actually scandals for Obama, but Russiagate, which is actually a fake scandal, is one for Trump. This is the problem with whenever courts create these crazy standards, they're really creating excuses to be super legislators, to be Platonic guardians, and recreate and craft the Constitution the way they want to see fit to see certain policies passed. So I don't like these intermediate standards, but theoretically the thought is that the degree that they're balancing it, they're balancing how badly are they really taking away a right of yours versus how justified is it what they're doing. How much does it benefit the state versus cost you in terms of rights?
And I guess, maybe a good example, or not an analogy, not a hypothetical, but a good example would be limitations on freedom of speech. I say limitations on freedom of speech, which would have to meet strict scrutiny versus wearing a seatbelt, which might have to meet intermediary scrutiny. I guess that would be a good...
Seatbelt, probably rational basis. So basically, if something is labeled arbitrary by the government, or someone says, hey, this was an arbitrary action, so it should be taken away, they only have to meet rational basis, which that too can vary, by the way. One day, rational basis means what the court determines is an evidentiary-based reason cited in the record. Another day, the court will say it's whatever the executive branch says it is. As long as the executive branch gave a reason, that is rational basis. So, that's why I'm not a fan of these levels of standards. I get the principle they're trying to get at. How do we balance the collective interests of the state against the individual interest protected in the Constitution? But my view is the Constitution already made that balancing choice. And if somebody wants to change that, amend the Constitution, don't amend it by judicial fiat. But that's what the issue is. But I think they're clearly right. When you're taking away the ability of half the country to have a means of self-defense that they've chosen, how does that not a severe burden on a constitutional right?
Well, it's also, now that I know so much more about American constitutional rights and history, the right to bear arms shall not be infringed. How is, determining you can own the gun, but you can't own the bullets? We're not far off from that slippery slope where you can own the gun, but you can only have 2 bullets a year. So how does limiting that not constitute an infringement that shall not be infringed under the Constitution? Yes. I could know where the courts should go. In Canada, I know where they would go because we don't have that same constitutional history for the right to bear arms. And if you want to know where the slippery slope goes, look at Canada. We cannot even own firearms for the specific purpose of self-defense, and it all follow the same sort of argument, like certain types of weapons. Certain types of capacity magazines, all of the rounds are limited depending on the pistol or the rifle. And you just see it happening in real time. And the rationale, like people are saying, I don't know anything about guns at all. They say, if it takes you more than 5 seconds to change a clip, whatever. Or you can own.
This is critical. Yeah, you have to sit there and load them bullet by bullet, like some old single bullet musket or something. Good luck with that when they come into the house.
And that was Jim Jeffries. Jim Jeffries had a. It was kind of a funny stand-up bit, nonetheless, on gun control. If anyone hasn't seen Jim Jeffries before he, became disingenuous in his politics, but so it's interesting. It's an interesting decision. I was flabbergasted because I thought it was unanimous. And then I was like, oh, look into the judges. They all came together, and lo and behold, they didn't.
The Ninth Circuit might take it en banc, but I think, but this is clearly right in the mainstream of the Heller decision. It's right in pace with that. They would have a hard time overturning it without contravening and contradicting Heller. And I'm not sure what the political profile currently of the Ninth Circuit is. It's getting close to being not as democratic as it once was. So, and I think it's a decision the Supreme Court would affirm.
Well,
if it went that way.
Well, even if it goes to en banc one way or another, presumably, would it go to the Supreme Court, or is this not a novel enough question for the Supreme Court to decide?
Oh no, it would be the biggest decision since Heller. They had a couple of petitions they turned down that were Heller related this past cycle. So I don't think they would jump at it. But if the Ninth Circuit were to reverse en banc, I think the Supreme Court would take this case. And if I were the government, I wouldn't push this case. If I was the state of California, because these facts set up very, very good for the Second Amendment side of the legal equation.
All right, and Forrest Stepper, thank you very much for the support, but you don't have to do that every time you want to question him. Do you mean there is no way to defend ourselves from the rioters or censorship? Well, we've been talking about the censorship left, right, and center. We've been talking about the rioters with the McCloskeys and the case at the Wendy's. When things get politicized, when the judicial system gets politicized, when the application of laws gets politicized, it's you never know. Sorry, that's not the one I wanted to bring up. You never know the way it goes. It becomes you're walking on legal eggshells to some extent, where defending yourself could land you with the charges and not the aggressors.
That question about the 15 rounds, it may apply there too. So I think you'll see more challenges to any magazine restrictions anywhere in the country. So I think that they need that magazine restriction to be much higher. And I understand the frustration about dealing with rioters and censorship. The practical reality in these politicized environments where the legal system has been co-opted, what it tells you is be proactive, because in my view, if Democrats win across the board in the fall, what you saw in Portland is going to become a national problem. So on both terms of rioting and in terms of censorship. So there'll be very few protected places left if the entire executive branch and the judicial appointment system is in the hands of the Democratic Party. This comes from a guy who was a Democrat from 1992 to 2015, effectively. So they've gone a totally different direction. They've abandoned the old civil liberties positions entirely. You just watch the ACLU to watch that happening. Very sad to see. I was a contributing member of the ACLU for many years. It's been terrifying, but the statist woke wing of the Democratic Party is an institutional control. And the net effect is if you want some legal action to be available to deal with censorship or rioting, then I think you look for the people politically who are going to be on that side. There are some Democrats out there who are, but find people that are going to be on that side of the aisle to curb censorship and curb rioting behaviors and politically try to make that happen. And then just be more self-informed, more self-educated, share the information with other people, support those that are providing this information and education for you, because a self-informed populace is a self-empowered populace. The first line of defense is always self-education.
I love it. Now I'm going to read through a bunch of super chats because my wife texted me from upstairs and said I missed. Tony Nieves says, Tony Nieves, thank you very much, by the way. I can't bring them up right now, so I'm just going to go through the pictures I took. So I've been developing a theory for a few weeks now. Every president of the last century who wasn't supposed to be president has met an untimely or has had an issue of violence. Teddy Reagan, unironically, the reason JFK was mob fixing Chicago, so prohibition tie. Interesting observation. No one should. Violence is never the answer, but you're always preaching to the choir whenever anybody says it. But it's an observation. Sarn0 says both sides are going to have people who don't accept the election results. But if Trump is reelected, I think we may see the worst political violence, or you won't. I mean, it's a tough thing to predict. It's people will live with the results one way or the other. Just depends on how bad the media stokes how bad the media contributes to eroding trust, the very trust that they accuse Trump of attempting to erode. Life of Brian says the constant hate campaign against the white Americans without a BA serves the same purpose as the grotesque caricatures of peasants in the Middle Ages.
It goes way back. I did a history thesis paper of this when I was at Yale about how there's a parallel in popular Hollywood culture between how it portrays poor whites and African Americans at key junctures. Now it's no longer culturally condoned to portray African Americans in that light unless you're doing it in a liberal framework. The left has a magical way of trying to portray the worst aspects of certain communities in the name of defending them. But that's been a cultural problem throughout, because anybody who has a dissident, independent narrative, a historical narrative that's separate from the institutional narrative, whatever that narrative may be over time, has historically been targeted for smear campaigns as a group by the powers that be. And this goes back to any dissident group of any time period. And different time periods, just different groups. But it's still true. Poor whites are still portrayed with an extraordinarily venomous approach by the institutional media and press. And at large parts, it's class bias. I mean, they come from places that don't understand those folks and don't care for them. But if Antifa keeps wandering into Southern mountains, good luck with that. Not because Southern mountain folk are racist or anything like that. It's because a lot of Southern mountain folk that for centuries have not cared for people coming into their neighborhood and just creating problems. So they got about 8 or 9 centuries going back to the Scotch-Irish mountains of defending their own. So we'll see how good luck with that. They'll have a death-proof experience. So we'll see.
All right, now I'm going to read these off my phone, and then we're going to do the last topic, which is not an in-depth, a good 15 minutes on Millie. Okay, Toby Warren says, your thoughts on the Ninth Circuit. Sorry, we got that one. Alyosha says, maybe briefly touch on the concept of legal fiction. We got that one. STFFFS, I got that one for sure. Can you ask Barnes what he knows in one way or another? Good information regarding Fulton versus City of Philadelphia, and specifically what he has to do with the Employment Division versus Smith.
Be honest with you, those cases have a vague familiarity, but not off the top of my head.
Okay, and we got Sam Barnes. Is California proposed 10-year retroactive wealth tax constitutional?
I don't think so, but it's going to be tough. You're going to have to get a court outside of California somehow to rule on it. The efforts, a state is supposed, what it's happening is the state of California is saying if you leave California, they're going to impose a wealth tax on you going back 10 years. So effectively, they're trying to create, the U.S. has an exit tax that says if you give up U.S. citizenship, you have to pay a tax. I think that's not constitutional either. Hasn't yet been challenged in the courts. The IRS usually compromises with me rather than allow that to be disputed in the courts on behalf of the clients that I've had in that context. And so I think it's the same restriction here. States' power to tax is limited to activities within its state, but doesn't stop California. So I think it is unconstitutional, but it's going to be hard. You're going to be hard pressed finding a court to entertain it unless you can get outside of California.
All right. Jason L says, did you know Clinton used literal acid wash on the outside of her server to destroy the bits of data saved on the chips within it? I did not know that. Okay. Sarn Zero, I think we got your question as well. Life of Brian, we got that. Al Dente, can we sue the ADL for false advertisements since they defame people all the time? Would it be a class action or go the Patreon suit and have many people file? I mean, I don't think you can do the
for defamation, it's still better to bring individual claims, and the hard part is getting a factually specific claim that's not a protected opinion. The ADL is very artful, like most of the media, that the way they lie about you, it's very tough to bring a libel suit. It's mostly by such indirect innuendo that you know what they have effectively told people, but the courts say, that's so vague, that's really just an opinion. So the key is you need something that's factual, that was inferred about you as much as possible. It doesn't have to be overtly stated. It can be inferred. Now, of course, you could be Alex Jones, and then they change all the rules, and suddenly anything can be called libel. That's the Texas standard. The Texas Liberal Court of Appeals, Democratic judges who sit in Austin, who all of a sudden everything applies. Those same judges will then reverse themselves, I guarantee you, in the future, when it's a liberal person or media person being sued, and suddenly go back to the strict rules that govern defamation. So it's just another sign of how politicized our courts have become. And just when people ask me, why do I focus more on Democrats than Republicans? Because practically, I'm just objectively speaking, I can't guarantee you what I'm going to get with a Republican judge in a political case. He really will go with whatever he thinks the law is, good or bad, more often than not. A Democratic judge can guarantee you what I can predict about 80, 90% of the time what they're going to do. So the sad reality is the left has gone a different direction. The right, large aspects of the right still respect the rule of law in the legal system. Large aspects of the left no longer respect the rule of law. They think the rule of law is part of the patriarchy or whatever nonsense they believe currently. But effectively, they don't believe in it as a principle.
Very interesting. All right. And we got I think people are hearing some noise upstairs. Zerosifer says, for Barnes, I mentioned before, but wanted to know, would a BB gun be covered under Castle Doctrine? A 72-year-old man was charged with assault for using one to stop a woman stealing a Trump sign in North Carolina.
Yeah, absolutely. Still, so it depends on the scope of North Carolina law. Would they consider someone stealing a sign, threat to property, trespass on a property? What kind of danger? Like in every state, you have different interpretations of the Castle Doctrine. Some require it be a threat to your imminent threat. Some require it be any kind of threat. Some of it require the kind of threat in terms of duration of time, is it imminent? Is it not imminent? Also, in terms of, is it something that is a threat to your property versus you physically? Different states have very different rules about this. So it depends on the state, but what weapon you use to defend yourself doesn't change the right. That includes whether you're driving a car, using a knife, BB gun, anything.
Okay, amazing. This is a 3X question. Kane Raw, and the currency was NOK. I don't know what that is, but I'll look it up afterwards. 3X question. If Trump loses and refuses to leave the office, if Biden wins but gets sick, will Kamala Harris get the VP? I think the person doesn't necessarily speak English as a first language, but I'm just reading it like this. We all know he's not well. Could Biden potentially undo Trump's good China work?
No doubt Biden would reverse Trump's China work very quickly. Democratic Party has a deep alliance these days with China. Even people like Robert Reich are, defending are critical of Trump for China tariffs when he's been one of the big been one of the big trade people for years on the left. So they've just abandoned any degree of independence of thought on that. Kamala Harris, I think they sort of let the cat out of the bag. People were saying that will reach another question about Kamala Harris citizenship.
Yes.
So I will get to that. But yeah, it wouldn't surprise me. Kamala Harris will be the de facto president if Biden is elected. And if Trump loses, he's not hanging around. If Trump really thinks they stole it from him, he may raise a little bit of a stink about that. But he never wanted to be Al Gore 2000. So what Trump is more likely to do is to thank the people that he would attribute being responsible for that with his pardon power. So I think that if he's basically signaling the deep state that if they interfere with the election, a lot of key high-ranking actors will likely be indicted if he loses the election. And secondly, that both Assange and my prediction would be both Assange and Snowden will be pardoned if Trump loses. As a payback to deep state that he blames for what happened over the last 3 years. Kamala Harris is two parents. She was born here in the United States. Her two parents were not citizens of the United States. So there are people who believe, going back to the McCain case, contrary to the media's narrative about birtherism being a racist conspiracy theory, actually birtherism as to Obama arose from the Hillary Clinton campaign, didn't arise from the right. And people on the right or people on the independent side, really, who were aligned loosely with the right, who were concerned about natural-born citizenship, often concerned about issues related to immigration, but they first raised the issue as to John McCain, not to Barack Obama in 2008, because McCain had been born on a military base. And so their theory is that to be a natural-born citizen, to qualify under the presidential clause, to qualify for the presidency, requires two things. You be born within the territory of the United States and one of your parents be a citizen of the United States at the time of your birth. Their views have never been affirmed by the courts. Now, the courts avoided the legal question in the McCain and Obama context by calling it a political question that they couldn't resolve. And so they basically walked away from actually resolving the issue. In addition, a lot of this, when people raised this, there was, I think, too dismissive approach by some in the media who are like, oh, that's just birtherism part 2. That can't be possibly true. Well, actually, it's not a well clarified legal doctrine, because we have a decision from the 1890s that said a Chinese citizen was still a natural born citizen, even though his parents were not citizens. But that was in the 14th Amendment context. But the degree to which that applies outside of that context has been left unresolved. So the anchor baby dispute gets into this, because the quote unquote anchor baby is someone who's born here in the United States to two parents who are here illegally. Now, in Kamala Harris's case, both of her parents were here legally. So that's another legal aspect. My own view is that immigration citizenship should be determined at the time you're born, not subsequently. You shouldn't be able to magically lose it because the law changed. And so we should look at what was the law of citizenship in 1964 when Kamala Harris was born. And there the law was quite clearly that if you were born in the United States, you were a citizen of the United States, period, regardless of the citizenship status of either parent. So I do think that people who are raising this question should not be just dismissed as somehow racist or bad people. They're people with a sincere question about who can become president of the United States, and does natural-born citizenship have a political loyalty that extends to your territorial place of your birth and to your parent being loyally committed to the government. So the idea is that the point of natural-born citizenship within the presidential clause was to make sure foreign royalty couldn't come over and co-opt the presidency of the United States. And in that context, they're not entirely incorrect when they point out that to a certain degree, they were anticipating that people who were run for president, their parents would have also been loyal to the U.S. government by being citizens at the time of their birth. But historically, the evidence doesn't support them over time on that, and legally, at least in 1964, the evidence clearly did not support them. So I have no doubt that both the courts and Congress would consider Kamala Harris a natural-born citizen. But the way in which this question probably should be best resolved, my view is it's never been a court question, that it's a Congress question. that Congress, before it certifies the election, can determine whether that particular candidate is a natural-born citizen to meet the presidential qualifications clause, and that they could decide that question. But politically, it's smart of Trump to put it out there because it will highlight the fact that Kamala Harris has very little connection to the United States. She would probably be the least connected person to the United States to ever be elected president. Some would say that about Obama, but I would not. Both because, one, both of her parents, unlike Obama, both of her parents were not from the United States, number one. Number two, she spent much of her upbringing in that very dangerous country known as Canada.
In this very dangerous city known as Montreal, going to Westbound High School right up the street.
Exactly. So I think politically it benefits Trump because it gets the subtopic of why would this even be discussed, and people are like, oh, so she's didn't really grow up here. Neither of her parents is from here. I think there are a fair number of people for whom that would leave them a little unsettled, wondering, okay, how deeply rooted are they in the American tradition, the American community, American ideas and ideals, if this is not really where they grew up, not that where neither parent came from here, and they didn't really spend most of their time growing up from here. And I don't think that's an illegitimate concern. I have no doubt, put it this way, if someone like me went to France and tried to run for prime minister of France or president of France, the French would be very unhappy with it. So
I'll be to put it mildly, Robert.
Exactly. So it's just because the French are extremely parochial that way. So this is a universal phenomenon. You get parts of Africa are this way. They didn't like it when people would leave to France and then come back and try to run their government, run their country. They didn't if they didn't have deep tribal connections. So because the different tribes really have a lot of political influence when you look at voting patterns within an African nation. So I think it's a legitimate question across the board in that respect. But I don't think, but it will clearly be resolved in her favor legally.
Okay, excellent. Now we're going to read through these. We're not going to answer them because we need to do Millie Weaver before we end this. Randy King, does the "to ourselves and our prosperity" clause, as noted in the preamble of the United States Constitution, carry any weight in the interpretation of intent as it relates to the 14th Amendment? I thank you for the... Say it again?
It can. That's the short answer is it can.
Short answer is good. We got I'm a Nobody says, question for Robert. Does it seem to you that the Supreme Court is to apply strict scrutiny or close to strict scrutiny to administrative decisions under Trump? We're not going to get to it now. It's pronounced stroke. Someone, not someone, but Rusted Android says, John Pepin says, would you like a free copy of my book, The Fourth Branch? Only if it's on Audible. I can't do books reading. Okay, and the rest I'm gonna have to miss them. Sorry, John, Christopher, I got the rest. Okay. 1 hour.
Yeah, I'll cover the last four topics in very quick order. So the TikTok case. Yes, the president can ban TikTok. He can force them to divest. It's not a takings violation because the U.S. is not asserting title to TikTok. It's under his foreign affairs authority, and Congress has given him statutory foreign affairs constitutional authority, commander-in-chief, statutory authority because they've given him international emergency relief that allows him to make all kinds of orders to freeze assets. This is how sanctions orders get issued against foreign assets. And there was already an emergency order issued as to China due to issues related to Hawaii and technology. And because China, he actually cited this in the executive order, was spreading the conspiracy theory that the United States planted COVID-19 in China and that they are using TikTok for discovery of data per privacy invasion purposes, gives them the constitutional statutory authority to do so. No court is likely to prevent him. So the TikTok order is likely legal and constitutional. Big tech case, people can look it up. Fortnite has wisely sued Apple and is going after and basically it's an antitrust violation because what it's called in particular is tying. So when you use your monopoly in one part of the market to force consumers to buy, or producers in this case for the purposes of consumers, to use another product you have, it's called you're leveraging your monopoly to create an unfair advantage in something else. That violates the Clayton and the Sherman Act, the Antitrust Act. That's why they sued. I think they will ultimately win, and we may be beginning to see the beginning of the end of Apple and Google Play's dominance over payment processing and app access in America. And credit to Fortnite for having the guts to go forward with that suit. The lawsuit is very well crafted and done. It's brought by an elite firm, a Wall Street firm in New York. But it's they have to sue in California because of their contractual relationships. But I do think they will ultimately achieve the result. It's a clear-cut antitrust violation. If antitrust law means anything, Fortnite should win their big tech lawsuit to start to break up Apple's monopoly over apps and Google Play's partial monopoly as well. Yale University is back to discriminating. So they were documented by the Justice Department for discriminating against Asian Americans. But here's the other fact that the Justice Department could have documented, but it doesn't fit within the easy racial discrimination laws. When I was a sophomore at Yale University, I led a protest group because Yale was going to get rid of need-blind financial aid and need-based financial aid. I think I detailed the whole story. Is it Eric Hunley, or am I blanking on his last name?
Yep, Eric Hunley.
Yeah, so people can look up Eric has what's the name of his YouTube show?
Unstructured is his podcast, and his channel is Eric Hunley under his
Eric
name.
Hunley.
Unley.
So people want the whole story, they can go there. I gave them the whole background of my little protest movement at Yale. But at the time, Yale was discriminating in favor of legacy students and against poor students. Yale promised to change that after I left Yale in protest. They apparently went back to their old habits 4 or 5 years ago, started discriminating again, this time against Asian Americans, white, anybody that wasn't African American, Puerto Rican, or Mexican American. And my guess is they are still discriminating on a class socioeconomic basis as well, that the people really getting shafted are low-income students, including, I believe, blue-collar students that may be African American and Latino. But the Justice Department's finally going to take meaningful action to try to prevent the Ivy League and big institutions from the systemic discrimination against Asian Americans and systemic discrimination, I think, against lower income Americans, as over 10% of Yale students are still legacy admitted. Basically, kids get in because daddy went there. I call it the George W. Bush admissions policy. How do idiots get to Yale? That's how. There's a few people still mad at me about that from Yale days, but that's another story. The way I used to put it is, if you've ever sitting in a class in Yale, and I said this as a sophomore, I was crazy. I was like, you're sitting in a class and there's some guy next to you that's just a total idiot. And you're wondering, how do they get in here? That's what legacy admissions is for. That's what donor-based admissions is for. So that covers the Yale discrimination case, the big tech Fortnite case. We have Millie Weaver and Julian Assange, I believe.
Well, we may not get to Assange tonight, but let's do the Millie Weaver, because I know people have been dying.
The nice thing is that the two are interrelated in my view. So with that further backdrop, what Millie Weaver was doing was she was going to release a documentary you can still see called Shadowgate, available at band.video. Also, I think currently still available on YouTube and different channels. On Friday, she was summarily arrested without any much explanation. She put out a short video while she was being arrested. The officers did not have an arrest warrant to give her, which is weird. And they said that she was under sealed grand jury indictment. They said something about burglary. What has come out since then, though I cannot confirm any of this, nor do I have direct access to the information, and I may down the road represent Millie Weaver if this case goes in certain directions, but do not currently. So
don't get the people too excited, Robert.
yeah, exactly. Yes. So it's going to depend on a range of circumstances. So to his credit, Ezra Levant, your friend, the guy you know up in Canada, the rebel, created a GoFundMe for her. He started it out at 20,000, and I was going to tell Ezra, the lawyers you hire for 20,000 are not going to handle political cases. That's your plea. Give people just a 2-second upshot on how criminal defense works. Any lawyer who charges you a low amount of money is expecting you to plead guilty and not expecting to have to work the file. If they're expecting to work the file, because it's often hard to withdraw from a criminal case, they usually require a big flat fee up front, because they often cannot get out of a criminal case if you quit paying, if they do any other structure. So typically, goes to the argument you were making about fees in the Keemstar case, to give people an idea for attorney's fees in big urban areas, high-profile political cases, average hourly rate is, on Wall Street, it's $1,500 an hour now. In a high-profile criminal case, $1,000 an hour. If you're at a mid-tier city, decent city, but million plus, but mid-tier, $750 an hour. Smaller city, $500 an hour. The lowest rate you get is, so top 1% of lawyers are $1,000 an hour plus. Top 10% are $750 plus. Median is $500 an hour. Bottom 25 is $300. Bottom 10% is $250. And imagine in a case like Millie Weaver, if you work at just 80 hours just of attorney time, that's 20 grand. So that's where it's hard to work a file correctly for a low fee unless you plan on pleading the case. So you'll get a lot of, like, you call up and say you got a DUI misdemeanor, lawyer might say 5 grand, 10 grand, 20 grand. That's because he just anticipates doing one day of work, no more. And his whole economic model goes out the door if he has to work the case. So Millie Weaver suddenly gets arrested. They allege burglary. What has come out since then, but it hasn't been publicly confirmed either by Millie Weaver or the courts, is apparently a parent was at her house some months ago because of the pandemic-related issues, was there at the house, saw a bunch of documents that she was looking at for her Shadowgate documentary, may have concluded that took photos apparently of the documents. The phone was taken from her because they were trying to protect the documents, gave her a new phone, and purportedly that's what may be, because she doesn't even know. I mean, she hasn't disclosed anything contrary yet. That may be the basis of the allegation of burglary, obstruction of justice, burglarizing records, obstructing of justice, something else with evidence, and domestic violence.
Yeah.
Now, apparently her mother has said something on Facebook. I can't confirm that it is her mother. Her mother said that while she originally went to authorities, she had told them not to go forward at all. I find it extraordinarily suspicious that this case justified an arrest.
A secret indictment to begin with. So I put on my video.
It reads just like Julian Assange. All Assange did was receive records from a government whistleblower. They allege he helped encourage it. So what? That's every reporter in the history of disclosing whistleblower records. I've never known a reporter to say, no, whatever you do, don't get me those records. That isn't what they say. So the criminal law has always said, for First Amendment purposes, you cannot put somebody in prison for disclosing records, regardless of whether those records were originally stolen, unless you personally stole those records. And so that's deeply problematic if they're trying to use the theory against Assange, where they're saying if you encouraged it, now it's suddenly life in prison. Are they doing the same thing to Millie Weaver right on the eve of her releasing her documentary that's all about this kind of illicit activities?
Well, so here's the pushback that and people are right to raise it. It might be our bias that it might very well be coincidentally her mother came to stay with her during the pandemic, witnessed child abuse between the parents, videotaped it, recorded it, whatever. Millie and her husband tried to steal the phone from her mother, which hence the domestic violence charges, hence the tampering with evidence if they tried to delete the video from the phone, hence the robbery. I think it's been changed to robbery from burglary, or at least that's what's been clarified. So that may be the entire story, and then just jumping to the conclusion that it relates to the documentary or the release of the documentary or any of the documents obtained in that context is a leap, an unsubstantiated leap that represents bias or predetermined direction we want to go in.
All I would point out is that that's exactly how they started out the Assange case. They said Assange was being charged with sexual assault. They charged him with rape charges. Those rape charges were bogus. He never raped. By the way, for people out there still think Julian Assange, he didn't rape anyone. The allegation was whether or not it was his fault that the condom didn't work.
Well, someone emailed me on this as well, because I did a series on Julian Assange back in way back when. There just hasn't been any news. The allegation was that he removed the condom during sex, which under Swedish law can qualify as sexual assault or rape. That was the allegation. He had consensual sex, but alleged to have removed the condom during the sex. And
in one case caused it to break, because in one case it was a broken. But it was like, well, for one thing, that to my knowledge, that has never actually been prosecuted anywhere yet. Because I would say there's a lot of NBA players, a lot of celebrities, there's a lot of people that would be like, she told me she was on the pill, and then all of a sudden I'm on child support. Do we want to call all of that rape allegations? Well, that to me is insane definition of sexual assault.
Well, and apparently Sweden has some of the most insane definitions under the law.
It probably does.
In other countries.
But probably selectively applied, because some of their way they've applied them in. There's some other immigration-related contexts where they've applied rather generous provisions to letting people out, that culturally somehow sexual assault can be excused. So it's the woke nonsense. The only thing Sweden's done right is how they responded to the pandemic, because their public health officials are so irascibly independent. It's the last good Swedes left in Sweden. But either way it breaks down, Julian Assange's accusation at the time was that this was entirely being politically manipulated to get control over him for U.S. prosecutorial purposes. Ultimately, all of the rape charges were dismissed. by the Swedish authorities. There was reason to believe that it was a setup in multiple ways, and he's now jailed waiting extradition, which would not have been possible but for those rape charges originally being brought. So my view is always what I tell people: maybe it's a coincidence that they're bringing these charges right on the eve of a documentary coming out that implicates deep state actors and various nefarious activities with two different whistleblowers. But in my personal professional experience, it is generally ill-advised to presume that coincidence is a coincidence until proven otherwise.
And so even let's just assume total coincidence, totally unrelated to everything. It's about child abuse. That's why they got both parents. I had an Ohio attorney. I vetted just to make sure they existed. I don't know anything more than that, which is why I won't use them as a source. But apparently, under Ohio law, it is incredibly rare to get a sealed or a secret indictment, which is a sealed indictment. Yes. For robbery and even for domestic violence, especially if it's a first case of accusation of domestic violence. So
exactly. Not only that, sorry, go ahead.
So even if it is the total coincidence, has nothing to do with the documentary, that's just we're putting things together. Even then, it's totally unheard of to have a sealed indictment executed on a Friday afternoon, taking both parents, leaving the kids alone, based on a squabble over a phone and some pictures, and what would otherwise be, from what I understand, first charges of domestic violence.
And the second irregularity is the time delay. If it's accurate, that was her mom's statement on Facebook, she was saying this happened months ago. I've never heard of them coming back. They usually bring it right away if they believe the case. Why multiple month delay? And so the other aspect of this is the hold, which you've noted being held without bail pending a judicial hearing on Monday. That may violate the excessive bail clause, depending on how they're doing it. They used to do it all the time. They'd pick up people late on a Friday to stick them in jail because they say, the judge not available till Monday. So that's deliberate. That's prosecutorial manipulation of the arrest timing for the purposes of creating the worst possible coercive conditions of being locked in jail. And over the weekend is the worst. They bring in all the worst people over the weekend, be stuck in with to not get bail. I've almost never heard of this. So, this is a summons case. This is you say, hey, you got to show up on court next week. So there's many highly irregular activities that are going on in that county. And for me, when you combine the irregularities with the timing of her with the arrest and the timing of her releasing this film, I'm going to be skeptical that politics was not the motivation until proven otherwise.
And and then I was thinking, even if it was a legitimate charge, this reminded me of armed FBI agents showing up at Roger Stone's house at 6 a.m. for what was being charged against him. Even if the charges are what they are, domestic violence, tampering with a cell phone, if that's what it is, this is taking a sledgehammer to a fly. Especially from what I understand, she was at a residence. She's got two kids and at a well-established residence. Flight risk is not exactly the biggest risk for someone of Millie, from what I understand of her now. So it's one of two things, neither of which make much sense. It's either directly related, and it's related to theft of documents that made it into the documentary, because there are some issues and questions as to the individual who provided those documents, or it's totally unrelated, in which case it really reeks of more of this selective prosecution against an overtly conservative individual with ties to the notorious InfoWars, and taking the full force of the police agency to arrest her on a first time domestic violence charge. How both parents get arrested if it's not against the kids, either way it doesn't make much sense, and we'll find out more. And with any luck, the indictment will be the indictment would have to be unsealed imminently, or no?
By Monday, without question. And it's all highly irregular, highly suspect timing. And, just to give a tangential connection to something different, but if you go back to watch the show, How to Catch a Predator, that show was about to expose a lot of misconduct with high-ranking officials in Texas. And suddenly the show got shut down. A bunch of people end up getting arrested. A bunch of other people end up getting released that were guilty of attempted pedophilia. That once you get close to people in power, suddenly there's a criminal justice investigation into you for something. So if you're on the wrong side of that political power equation, there's a long history of it in the United States. It's gotten really bad over the past during the people opposed to Trump. So I'm going to operate with that as my operative assumption until proven otherwise. Possible, highly unlikely that politics did not taint this case.
Yeah, and I say one way or the other, it looks if at first glance, one way or the other, it looks like politics is at play, and you cannot criticize people for being skeptical. I love the Gore Vidal expression. We're not conspiracy analysts. We're not conspiracy theorists. We're conspiracy analysts. When you see what's done in the McCloskey case, when you see what's done in Amy Cooper case, when you see what's done or not done in other cases, and then you see this, you cannot fault people for putting two and two together. And that's it. It's we'll see what happens when that indictment comes out, and with any luck, someone who will be able to get our hands on it. I'm going to do a follow up. When I compared it to the CNN coverage, ostensibly there should be some sort of more outrage, and I should be able to find more information of this story other than on websites like MEAWW or other stories. And something I said on Twitter, like when the media cartels avoid these stories, the only places you can find information are on fringe outlets, and then it allows everyone who doesn't want to read this to say, so that's just from some fringe outlet. It's got to be fake news, only because the cartels are not reporting on it. And exactly. Everyone should be reported on. If it's related to the documentary, it reeks of what you mentioned on Twitter, that this is corrupting the idea of going after people for publishing what might be leaked information. And if it's not, how in the name of God's green earth can this be justified for this type of offense? The Friday afternoon special to lock up two parents of two young kids over the weekend on robbery. If it relates to a cell phone, it doesn't make sense, and people are trying to make sense of it. But the news will come out, and there will not be a total media blackout because there'll be some people talking about it.
And apparently they scheduled a CPS hearing to try to take away their kids Monday morning. So it's a shock and awe campaign by, I suspect, a partisan motivated prosecutor who probably understated the people who would be paying attention to this on the right. This is because the people that have been waging war on Alex Jones sort of assumed that he did not really have a big audience. Millie Weaver does it. She's a contractor. She has her own show. Millennial Millie does her own thing, but she does contract work as well for InfoWars. They have millions of followers all across the country. So the idea they could get away with this without anybody paying attention is probably a mistake they may have made.
All right, and with that, I'm going to bring up the last of the super chats. Nathaniel McLaughlin, always love hearing from you guys. Any chance you could devote some time to going over the Michael Strickland case in light of the McCloskeys? I'm an Oregon resident, and the anarcho tyranny is scary. It won't be on this. Stream.
I represent Mr. Strickland on appeal, so so I can talk about that case next. We'll do that next show or the show thereafter. I got a great guy laughing at libs. People can look him up on Twitter and other places. He's the guy who tried to defend himself, and they charged him with 17 crimes instead.
All right. I have no knowledge of that. So Robert, you'll send me some reading material before we do it. Far Stepper, thank you very much. The movie is called Shadowgate. Watch it and share y'all. I'm going to go watch it. I'm going to watch it with curiosity, with skepticism, like I watch anything else.
There are aspects of it I couldn't verify and that I didn't necessarily agree with, but it's actually very well done because they do a lot of. They include excerpts from congressional hearings and press reports. Which, you know what, when I was watching, I was like, man, I remember that, but I really didn't put that in context, and I realized that in context it has a much more clear meaning. There's been other people that have been talking about there was likely a bunch of third-party contractor abuse of Fisa records during the Trump campaign that they're trying to suppress. It actually happened before. It happened back in 2008. Somebody got Hillary and Obama's passport records, illegally leaked it. They promised it wouldn't happen again. The Inspector General of the State Department said people were doing problems and he had to have his own internet system. So there's been a history of when you consolidate records, expand the scope of what records are in there, and then give easy access to corrupt third-party actors, you've got the recipe for a problem.
All right. Patrick says, glad to see you orange shilling for the NWO. It is good. The pay for what we do is much less. I suspect. Oregon, STFU, much love.
It's like Nevada. I prefer Nevada because that sounds better than Nevada. It sounds like a sheep saying Nevada. I know all my local Nevadans tell me it's Nevada. I'm like, why do you want your state to sound like a sheep? That's why I prefer to say I'm from Tennessee anyway.
I think it's Chaz Smith. It is Chaz Smith. If you guys don't know who Chaz Smith is, check him out on YouTube. He has a funny bit where it's called mispronouncing names, and he does an amazing. It was the funniest thing on earth where he deliberately mispronounces states, but humorously, not like to mispronounce them. Okay, people, that's it. We're gonna call it in now. I can hear some I can feel my wife's aura calling me upstairs now. Thank you all for tuning in. This was our record, Robert. I think we hit 6,500 people watching live.
Ah, fantastic.
Fantastic. So knowledge is spreading, and now each of you go spread the knowledge to somebody else, and knowledge is the one gift you can never take back. I'm going to write that down.
Yeah, it's actually a great statement. The two great schools of learning you can never close are the archives of nature and the rights of conscience. And that's what learning is, really. It's that if you listen to those and gather information about the world, you'll be in a position of true power.
I love it. I love it. Okay, I'm gonna say goodbye to everybody. Robert, thank you very much. Stick around. We'll say our proper goodbyes afterwards. Everyone, thank you very much, and I will see you in the next vlog. And check out all of Robert's stuff. All of the stuff is going to be in the pinned link, so you can find all the links there.
Yep, and you can subscribe for free, and remember to comment because it feeds the algorithm.
This is true. All right, guys, enjoy what's left of the weekend. Have a good night.